beginning here. My colleague Gene Gallagher, our San Francisco and Peninsula broker, does a longer purchase agreement class over 2 days. It's something like 8 or 10 hours of class. She goes through the purchase agreement line by line. She goes through every paragraph of the 16, 17 page purchase agreement. Um, and what I try to accomplish in my class as an alternative is a look at the substantive pieces of the purchase agreement, really the dynamic pieces that change from transaction to transaction, or the pieces that we're actually tailoring in order to write an offer and to communicate our client's desire when we're working on the behalf of a buyer. The general terms and the understanding that we're trying to create with a seller to purchase their property. So again, it's a pretty fundamental look at the purchase agreement. So you'll see in the folder that I shared, and I'll share it again because some folks just joined. The folder that I shared has a bunch of different documents in it. The main focus today is obviously going to be the purchase agreement itself, but when we're working with the purchase agreement, there are other documents that kind of come into play. So we need to be aware of what they are and kind of have a little context when it comes to those other documents. So first of all, let me just ask if somebody could give me a thumbs up or let me know if everybody can hear me okay, and if they can see the document on the screen right now. So it sounds like I'm getting some thumbs ups to both of that. Anybody that wants to show their face, that wants to get involved, it's more than welcome here. I think we learn more when we're kind of interactive. So I will be going over the document, but please jump in, engage if you have something that you want to add or question. So as I was saying, the folder that I shared has a bunch of different documents in it. I want you to have them all because they're somehow, they're connected to the purchase agreement and the way that we use the purchase agreement. We might not get to every document in the package, but we'll get to the ones that we definitely need to review in detail. And we're going to start with the actual residential purchase agreement itself. So that's the document that's called residential purchase agreement. But you'll see on my screen that you'll see a disclosure regarding agency relationship. So, because there are some new folks coming to these classes, I got to start from the beginning. And that means talking about some of the disclosures that are automatically attached to the purchase agreement every time we pull one from the CAR library. These documents that are attached to the purchase agreement are meant to stay attached to the purchase agreement. This disclosure regarding agency, for example, that we're starting with it's required that it tag along with the purchase agreement when we're presenting it to our client and when we're sending it over to the seller for a review. The disclosure regarding agency is also attached to our listing agreements and our compensation agreements in real estate transactions. And it's attached for a reason. It's attached because it's a required document that's supposed to kind of lead off these discussions so that the consumer understands how agency works in California. So we're gonna really get into some details when we talk about the purchase agreement, but I have to at least cover these disclosure documents. I do give another monthly disclosure. I do give another class in disclosures. I usually do it monthly. I'm actually doing it next week, and we'll go over these disclosures and some others in more detail, but I have to touch on these before we get to the purchase agreement. This disclosure regarding agency that stays attached to our purchase agreement sets the stage for the buyer first, and then the seller, letting them know what my relationship to them is in a real estate transaction. It talks to them about how agency works in California, and it informs that consumer that agency can take shape in a couple of different ways. I can be acting as a seller's agent, I can be acting as a buyer's agent, or I can be acting in a capacity where I'm representing both sides of a transaction or acting as a dual agent. The document goes on to inform the consumer about some of the duties that they can expect to receive when I'm acting on their behalf. Diligent exercise of reasonable skill and care, a duty of honest and fair dealing, and a duty to disclose all facts known to the agent that materially affect the value of the property. So it kind of sets the stage, and it's required by law, and we include it with, it stays attached to all of our offers. So that's what we're looking at in pages 1 and 2 here. The first page really kind of speaks directly to the consumer, tells them about these relationships, and then the second page is the civil code that informs the law, or that creates that shows the actual law. The second document that's automatically attached to our purchase agreements every time we pull one, and is also attached to our listing agreements and other commission agreements, is this Fair Housing and Discrimination Advisory, the CAR form FHDA. And in summary, this form is reminding the consumer that when we're helping facilitate the sale of real estate in California, when we're working on behalf of buyers or sellers, or when we're acting as the principals in real estate transactions as a buyer or seller, that we're doing so first by creating a level playing field. We're looking to sell a property, get the best possible value for a seller, achieve the goals of the buyer, but we're not going to discriminate against different parties while we're doing so. We're not going to look at things like age, race, gender, marital status, or any of the other protected classes as a defining feature that helps us decide how a property is going to be sold. So I think that we can all get on board morally and ethically for why we need to be clear about this from the onset. That's not how we want to do business. It's not lawful for buyers and sellers to do business in a way that discriminates, and we want to set the stage with a document like this to make that clear to everybody. So that's what this Fair Housing Advisory does over 2 pages. You should really familiar yourself with this document. It's in all of our disclosure packages. It's attached to our forms, and in your real estate exams, you became familiar with some of the Civil Rights Acts and some of the legislation over the years, statewide, federal legislation that protects people from discrimination, and it's valuable stuff. And you should become acquainted with the form. The next form that is always attached to our purchase agreements and listing agreements is this possible representation of more than one buyer or seller, disclosure and consent. So I mentioned the purchase agreement, and I mentioned the disclosure regarding agency, and I talked about how it sets a stage to inform the consumer about what they can expect of a real estate agent in California, what the role means, what kinds of roles we can take as a buyer's agent, seller's agent, dual agent, et cetera. Well, this possible representation form takes the conversation a little bit further along. It sets out some expectations, or it allows the consumer, the buyer or seller, it lets them in on some ways that a real estate transaction can kind of start to form later on down the road. So we're telling buyers and sellers, hey, there are certain circumstances where, as your agent, I might be representing multiple buyers or in a transaction, or as a real estate agent, I might be representing multiple sellers in a real estate transaction. And here's what that means. Or there are certain circumstances where I might be acting as a dual representative. So just in kind of a brief context of how this would look. So you'll see on the form, the first example that's given to the reader is that there are certain circumstances where a real estate broker might act on behalf of multiple buyers. And the example here would be if a property was available 123 Main Street, and I, Eddie Moran, was acting as a real estate salesperson, and I had two sets of buyers come to me and say that they wanted to write an offer on that property on 123 Main Street. Well, I'm letting them know in advance with a form like this that it's possible that something like this could take place, that I could be representing their interests, preparing an offer on their behalf, and I could potentially have some other party ask me to write an offer as well on that property. We make some decisions ourselves as real estate business people, whether or not we want to go ahead and represent multiple different parties in their attempts to purchase the same property. We make decisions about whether or not we want to dual represent in real estate transactions. And I would say that, most of the realtors I know would, if they found themselves in a situation where they were asked to represent multiple buyers who were looking to make a purchase offer on the same property, they'd probably refer out one set of buyers so that they could kind of eliminate the conflict. But it is possible, and it is something that we need to let the client know in advance could potentially happen. Um, the other kind of concept that you need to understand here is that anytime the broker represents multiple parties, say multiple buyers on a transaction, then the context here in this form is saying that there is a kind of agency happening from the brokerage to multiple parties, and it's something that you should be aware of. So I need to back up in this little piece. So every salesperson in California and every broker associate in California hangs their license with a brokerage. And in that brokerage, there's a corporate brokerage license number and a broker of record that hangs their license in association with that corporate number. And every transaction every salesperson does is affiliated with that brokerage and that broker license. So when we're talking about agency, we're actually talking about the brokerage's agency first. We're talking about the brokerage's agency, the brokerage's relationship with the client. So there are plenty of circumstances where this multiple buyer situation that we just talked about could actually take form where I may be working for a brokerage and I have a buyer client, and then somebody else on this call, like Mary Louise, I believe it is Marie Louise, is that right? Is representing another buyer. But because we work for the same brokerage, the broker actually has a responsibility to both of those clients, And in essence, the broker is acting on behalf of multiple buyers looking at the same property. So remember, when we're talking about agency, we're talking first about the brokerage's responsibility. So we're letting the consumer know that there are multiple situations where multiple buyers might be represented by the same broker, multiple sellers might be represented by the same broker. Maybe there would be two competing properties, both on Main Street, 123 Main Street and 125 Main Street, two different sellers, but they have the same brokerage representing their interests. Well, this is just almost like an advisory that is getting everybody on the same page prior to us getting into contract, prior to us helping fulfill a real estate goal. It's letting folks know that all these things are possible. Dual agency, again, would be that circumstance where the brokerage is representing two parties in one transaction, two different sides of one transaction. We get into this stuff in real detail in our disclosures classes, but that's the general idea. The wire fraud advisory is exactly that. It's meant to inform the consumer that there are a lot of scammers out there in the world. Those scammers can trick people with emails into all kinds of crazy things. One thing that happens in the real estate community is that there are scammers out there that try to represent themselves as a party to a real estate transaction, somebody like an escrow officer. They'll send out an email saying, send those wired funds to this wiring address on this date. and it happens, and people get scammed out of money. So we're trying to inform the client really at go here when we're preparing a purchase agreement with them, that they need to be careful all along about wire fraud, and that they should check and double check the information that they're receiving and make sure that they check with their agent um, before wiring money. We have a buyer's homeowner insurance advisor that was just added this summer to our purchase agreement package. Uh, Anybody who's been in real estate for a while knows that we're in a particularly challenging time when it comes to getting homeowners insurance policies for some properties. A lot of the insurance market has left our state. And it's a little bit more challenging to get homeowners insurance. So we're letting the consumer know right away how important insurance is, that they should be looking at their options, early, and doing their research, and making sure that they can procure homeowners insurance on a property. And then after all of that, we are finally at the actual purchase agreement. So that's the stuff that I have to kind of go over before we get to the meaty stuff here in the purchase agreement for this class. So the first thing that I like to point out in my purchase agreement classes is that you'll see that the form is actually called the California Residential Purchase Agreement and Joint Escrow Instructions. So the reason that I point that out is that, when we think about the offer document, we think of it as this kind of conversation between buyer and seller, coming to an understanding, making a binding agreement about the purchase of a property. And it is all of that, but it's more. It also acts as instructions to escrow. An escrow is a neutral third party that is kind of acting almost like a neutral referee in a real estate transaction. We provide them with the purchase agreement once it's fully binding, once it's fully executed, and everybody agrees to the terms. And they have certain duties in a real estate transaction to make sure that it flows properly. They account for monies during the transaction and timelines and all of the rest. And they need the instructions about what we all expect to happen, what the buyer and the seller expect to happen. They need to kind of be able to kind of keep track of that themselves. So this purchase agreement, the first thing I'm pointing out here is that it serves two purposes. It acts as an agreement between two parties and as instructions to escrow. So let's address this idea that it acts as an agreement between two parties. I like to start this purchase agreement class by talking about the purchase agreement in this state, in this original state where maybe it's been blank. You and I have logged into our Zip Forms account where we fill one out, and it starts off as essentially a proposal. It starts off where, somebody on this call who's representing a buyer has been working with their buyer client for several weeks. Or maybe months. They've gone and seen properties with their client. Their client has spoken to a lender or figured out financing, how they're going to pay for the property. The client has instructed you, their agent, what it is that they're looking for. You've had a buyer representation agreement signed with your buyer client that makes clear what your obligations to them are and what your expectations of them are. And you've kind of been through this process together. You're already working together. You're already trying to, you've already established a relationship, and you've already looked at properties, and they finally found the property that they like, right? So all of that happens first before we ever get to the purchase agreement. This relationship is built. The client has done some things they need to do to get themselves prepared. They've looked at properties and they said, hey, Eddie, I really want to write an offer on that 4937 Telegraph Avenue property we saw together. So we start here. We start with what's originally or at first a proposal. It's we're putting together in on this document what it is the buyer envisions, what they'd like to accomplish, how they'd like to purchase the property. The thing about this proposal is that they're going to put their signature on it at the end of us kind of working and tailoring it together. And once they have their signature on it, we're going to send it over to the seller. And at that point, the buyer is saying, you know, when they put their signature on this, they're saying, I'm comfortable with these terms, with everything we've written down here. This is how I'd like to structure this purchase. I'd like to pay a certain amount. I'd like to have certain contingencies. And I'm ready with my signature to say, if you'll accept this proposal, all you need to do, seller, is sign it. And then we have a binding agreement. So by the time that we get to that state where the buyer signs it, you know, we're creating this proposal, this document that we're basically saying we're good to go. We'll commit if you'll agree to this, seller. So we start the purchase agreement as a proposal, and then once the seller evaluates it and decides whether they like the terms the way they appear, they'll either sign it themselves and create a binding agreement where everybody has a clear obligations, or maybe they'll take that proposal and they'll lob back a counter proposal or a counter offer. And they'll say, well, I like some things about that, but I'm going to lob back this other form that changes a few things. And at that point, it's in the buyer's court again. And then the buyer says, it can say, you know, I'll take it just like I read it here in this counter proposal, or I want to lob one back over. So I kind of think of it almost as like a tennis match until we get to that agreement. But when we first start out with this proposal that we're writing to purchase a property, we have to have a clear conversation with our client and make sure that they're ready, that the way that we're positioning ourselves here, that they're comfortable with it. Because if the seller agrees to it, they're committed. Everybody's committed. So the client has had the conversations they need to have, the buyer client. They've speak if they have the cash to purchase the property, you know, they've shown you, their agent, the fact that they have that cash available. They've given you, you know, bank statements or some other asset statements. If they don't have the cash outright to purchase the property, they've gone through certain steps to get the, you know, to have their situation vetted by a lender. They've gotten a pre-approval and they've provided that to you. You've been to houses, all the rest, and you've had the discussions you need to have. And then we land at this moment where we're going to fill out this form. So I just need to get that all out of the way because I'm going to reference back to some of these discussions that the buyer has had up to this point when we go through the form. So the form starts out fairly straightforward, and you know, I think easy to understand. We're going to write the date prepared, whatever day it is that we, their agent, start to write this up. We do, for, you know, because there's a lot of new people on this call, so we do get this out of our CAR membership, out of our CAR membership. We go to our Zip Forms library and we pull up the residential purchase agreement. We write in the date prepared. The first entry, this whole first section is pretty self-explanatory. We're going to go through it. The first thing that we do is we tell the party we're about to propose this offer to, we tell them who the buyer is. We identify the person who's proposing to purchase the property, Beatrice Buyer and Benjamin Buyer. We write the accurate address of the property. We write the city, the zip code, the county. I should have the county filled in here, Alameda County, and in my mock-up. And we write in, whenever possible, we write in the assessor's parcel number. I mentioned that once we're at this in this situation where we're ready to write an offer, we've already been through a lot with our buyer client. They've actually gotten their pre-approvals. We've had lots of conversations. We've looked at lots of houses with them, and ultimately, when they're choosing to write on this house, it's a house, generally speaking, that was on the multiple listing service or MLS. We have all of that information in front of us, and we're going to use some of that information to help fill in this form. So things like having the accurate address or having the assessor's parcel number, it's going to be readily available on that MLS sheet or multiple listing service sheet in front of us. And similarly, we're going to have to fill in some kind of identifying information about the agents involved in the transaction. We're going to fill in who the seller's agent's brokerage is, and what the seller's agent's broker's license number is. We're going to fill in the seller's agent's name and what that seller's agent, the agent themselves, what their license number is. We're going to fill in our affiliation. We're going to say, that our brokerage is KW Advisors, and we're going to fill in our brokerage license number. We're going to identify ourselves as the salesperson or broker associate for that brokerage, and we're going to write our own personal license number in. So when you're looking again for some of this information that is not your own information, when you're looking for the information for the other side of the transaction, again, this is going to be available to you on that multiple listing service sheet that you've got in front of you, that MLS sheet. In addition to identifying the parties, the agents in the transaction, we have to, make a clear choice as to who that agent or brokerage is representing. So I mentioned when we were looking at some of the disclosures that came before the purchase agreement that there are circumstances where, maybe a seller's brokerage might not just be representing the seller, they may be representing both sides of the transaction. They may be representing both buyer and seller. So we need to be clear here when we're identifying the seller's brokerage. Is that seller's brokerage just representing the seller, or is the seller's brokerage actually also the brokerage that's representing the buyer? In our scenario here, we've got two separate brokerages, one on each side of the transaction. So we're just checking seller. And then we're doing the same for the agents. Is this agent representing just the seller in this circumstance, or are they representing both? We need to be clear about that. So, a lot of this first section of this first page is largely kind of, biographical information, the who's who of the purchase agreement, who's purchasing, what's the address of the property, who are the agents, and who are they representing, what are the agents' license numbers, and that's all pretty straightforward, and it's how we start our transaction, how we start our purchase agreement. But then as we come down the page, we get to the real meat of a real estate purchase agreement, and that's this paragraph 3 that you'll see all that encompasses this huge kind of spreadsheet view. You see, with all these columns and rows for 3 pages here of columns and rows. We call this the grid. So this was just added a couple of years ago to our purchase agreement, and it was added by our car attorneys in this grid format so that we have one kind of clear place where all of the kind of moving terms, the tailored terms in a purchase agreement can appear. So that anything that we're tailoring specifically for the purchase of this property appears, most of the substantive terms of the agreement appear right here in this 3-page grid. So in my purchase agreement class, the class we're doing today, we're going to spend a lot of time in this grid. The actual purchase agreement form is 17 pages long. But if we flip through these 17 pages, I'll give you a kind of view past the grid. We're going to see a lot of paragraphs. So the grid paragraphs are active. Like there's actually some action that we need to take. We, as the agent representing the buyer, we actually have to mark certain boxes, tailor certain terms for our client, enter in numbers, enter in kind of some of what is expected, what we're proposing. But when we get out of the grid after those first 3 pages, the rest of the form is largely informational. It tells us how the agreement works. The rest of the form are just paragraphs. There's no action steps needed here. If you can see kind of what I'm scrolling through, there's initials at the bottom of the page, so everybody can show that they've read everything and seen everything. But largely what we see here, this isn't stuff that we're actively working on when we're filling out an offer. Everybody in this room or virtual room should go and read through a purchase agreement, start to finish. If you have the ability, attend one of Jean Gallagher's classes where she'll go through every single purchase agreement paragraph, and you can go through the ins and outs of the if this, then that, what happens here. all of the kind of the defined aspects of how a real estate transaction works can be found in these later paragraphs. But again, let's go back, and there's 17 pages of it essentially until signatures. But again, most of the kind of substantive information that changes from one purchase to the next is going to appear in this grid. Those things that are going to separate one offer from another offer are going to appear in the grid. Things like how much are you offering for this property? How many days until you close escrow? Do you need a contingency? Is there going to be a loan? All of those things that change from buyer to buyer, from house to house, that's all going to happen here up front. So when we talk today in our purchase agreement class, I like to tailor this class so that it's a class about preparing an offer on behalf of our client. So most of what we're going to spend our time with today is this grid, because this is the moving pieces, the change. So here we are on our first page again. We're going to spend some time looking at these first three or so pages where most of the moving parts are. We've had a conversation with our client. We've shown them lots of properties. They've talked to a lender. They know they love 4937 Telegraph. They know what they want to write an offer on it. Before we write an offer on it, we're going to look at comparables. We're going to go on to the MLS. We're going to look for other properties that have sold near 4937 Telegraph Avenue, properties that have kind of the same attributes as 4937 Telegraph Avenue. By the way, for anybody who doesn't notice right away, that's the address of our actual Oakland Keller Williams building. I just use it for this mock-up. But in the scenario we're talking about, we're sitting with a buyer, they love the property, and we've done a little bit of research. We've actually gone and we've provided them with comparables. We've provided them with a view of the market, a view of what's sold recently, and that is similar to 4937 Telegraph, so that our client, Beatrice Buyer and Benjamin Buyer, our clients can make an informed decision about what they want to offer on 4937 Telegraph Avenue. Some of what we've considered is also how much activity 4937 Telegraph Avenue is getting. Are there a lot of people that are going to be writing an offer on this property? Do we need to be competitive because multiple people are coming to the table to write an offer? And we're going to provide the best possible data for our client, put it in front of our client, and ultimately our client is going to make some decisions. And that's when we get to this grid that I'm talking about. That's where we get to our specific buyer with their specific needs and their specific feelings about 4937 Telegraph. This is going to change every single time because you have to put all those elements together before you start to know how an offer is going to look. So with this hypothetical client, we've gone through all of those comparables, and they've set their mind on a price and some terms that they feel comfortable with. So the first piece of this paragraph 3, again, the grid is all paragraph 3. Everything in this 3-page grid is considered part of this paragraph 3. So the first thing we have here in this paragraph 3 is 3A, purchase price. It's pretty self-explanatory. How much are you willing to offer for this property? And again, our client has had the ability to review comparables and make an informed decision about what they want to purchase the property for. But let me point out a couple of things about the way the grid works. So you'll see the first paragraph, the header in the grid, it says paragraph number, paragraph title, contract terms, terms and conditions, and additional terms. So let's break it down. So if we're looking at paragraph 3 and then we go to 3A, the first thing we're going to see, the first column that we're going to see next to the column number is this paragraph number column right here that my cursor is kind of going over here. Oops, clumsily going over. This paragraph number column. In this column, when we're working in the grid, we can find kind of a referenced paragraph later on in the purchase agreement that can give us more information about the given line that we're on. So if we're in this 3A that addresses purchase price, we can have we can go find more information about purchase price by heading over to paragraph 5 and 5B of the purchase agreement. So let's give it a try and then we'll come back. So here we are in paragraph 3. And the first thing we're going to deal with is purchase price. And we're told, hey, if you want more information on purchase price, go to 5.5b. So let's scroll through and we'll find paragraph 5 and 5b. And like I said, the line in the grid was about purchase price. Well, here we have more information, additional terms affecting purchase price, things that somebody should know about purchase price, right? 5B, it actually said on that line about cash offers. Well, here's some additional information about cash offers. So anytime you find yourself in the grid, filling out these kind of moving parts, these terms that we're telling for the offer for our buyer client, and your client or yourself, when you need more information about what you're looking at, like when you're about to fill in about expiration of offer, look over to the left here. There's probably a corresponding paragraph later in the purchase agreement with more information about what we mean by expiration of offer, with some more details and kind of some explanation about what the expectations are and how the contract works. So it's just something to point out. But let's get back to filling in the grid. So we start with 3A, which deals with purchase price. We're reminded that we can go to paragraph 5 if we want to learn more about purchase price. Our client has already decided they want to offer $1 million for this property. We fill it in. If our client were to come to the table with all cash and not need financing, we check this all cash box. I would probably say 8 out of 10, 9 out of 10 transactions, our clients don't have $1 million in cash ready, available, liquid, ready to purchase a property. So in most circumstances, we don't check this all cash box, because in most circumstances, our buyer client is going to need to obtain some financing. They're going to need the help of a lender in order to purchase property. So when we deal with the mock-up that I've put together, it's always going to deal with the more common occurrences. So because I did this mock-up of a buyer who wants to purchase $1 million property, I didn't check all cash, because most of the time we don't have an all cash client. So we're just going to go to the next line, close of escrow. In real estate transactions in our part of California, I would say that the standard real estate transaction is about a 30-day escrow period from the time that an offer is accepted to the time that an offer changes hands and somebody gets keys to a buyer gets keys to their new property. It's usually about a 30-day period after acceptance. However, the buyer who's tailoring this offer, after consulting with the lender or the person that's offering the financing, after consulting with their agent, after reviewing certain documents, they may decide that they don't need 30 days. Maybe they'll decide they need 21 days or 28 days to close escrow, and they can change this number. But I'd say that usually we're talking about 30. You also have the opportunity or the ability to write in a specific date. So rather than, writing an offer today on October 9th and saying, well, close 30 days from now, you could say something specific, like we plan and hope to close on November 11th or November 10th. We can be more specific than 30 days. Whenever we're talking about the close of escrow date, there's certain, when I started talking about the first page, when I started talking on top of this page about having conversations with our client, the things that we do before we even write an offer, one of the things I said we do is our client is going to have spoken to and had conversations with a lender. They're going to have a pre-approval. They're going to have that relationship going. When we're writing an offer with our client, that lender is going to be a kind of partner to us all in the process. So we need to consult with them about some of the terms that we're filling in with our clients. So our client may decide that they want a $1 million purchase price, but we can only fill that in if they in fact have $1 million in all cash, or they have a pre-approval letter that shows that there's a lender that's willing to give them $1 million. Like we still need to, be consulting with that other party, to make sure that the terms are doable, that it's something that we can accomplish. And similarly, when we're writing the close of escrow, the number of days for a close of escrow, it's the client, it's the buyer who's going to make the decisions about what they want filled in. But we have to work as a team with the lender. And your job as a real estate agent is going to be, upon the time when you're writing an offer on behalf of a client, is to check some things out with that lender, get the permission of the buyer to have conversations with the lender that they're working with, to give them a call and say, hey, Mary, over at, Bank of America, I have a question for you about Betty Buyer. Can she actually close on this offer? We're about to write an offer on Telegraph Avenue for her. Here's what the property's like. You wrote her a pre-approval. Is it possible for us to close in 30 days? We're going to need to get buy-in from some of these other players that are going to have to actually perform during the period that we're in contract. So we're filling in, we're coming to an agreement on amount of days to close escrow, and we're going to fill that in here. Something that I will say about things like close of escrow, and about so much of what we're filling into this form when we're structuring an offer, is that we're doing our best on behalf of a buyer to write as competitive an offer as possible. The assumption being, in so many circumstances, particularly in the Bay Area, we have a competitive real estate market. So when a buyer wants a property, they are sometimes, and actually quite often, not the only party that wants to purchase that property. So we have to think strategically, and our client has to think strategically about what these terms that we're putting into the offer look like, because they have to think from the perspective of the seller who's going to be reading this proposal, and make some decisions in advance about how to be the most competitive they're able to be, and how to be the most competitive they're willing to be. So, when we fill in something like how long the close of escrow is going to be, there are general understood, there are generalities like 30 days for a close of escrow that happen in most transactions. But when we're structuring it, we may find out that the lender can close in 21 days. And our buyer client might say 21 days sounds great to me. And as the buyer's agent, if we're hearing that from the lender and the buyer, we may want to advocate for plugging in 21 days here, because again, we're thinking strategically about what's going to look the best if we're in competition to purchase this property. If a seller sees two offers with terms that are fairly similar, but one of them has a quicker close with 21 days, it might give our buyer client the advantage that they need. And that's the truth for almost any of the terms that we're helping our client fill in on this form. We have to balance the decision. Our client has to balance the decisions they're making with their comfort level, and with their desire to get the property, and with how to be the most strategic about going about getting the property within their comfort zone. So we'll leave it at 30 days here, but sometimes we shave that number down. Expiration of offer, this next line, is exactly that. We're lobbing over a proposal, I said in the beginning of this class. We are saying to the seller and the seller's agent who are reading this document after we're done with it, we're saying we're going to offer certain things, but and we're going to put it on the table. And if you accept it, we're going to be in a binding agreement with you, but we're not going to leave it open-ended. We're going to make our proposal something that expires at some point. So how long are we going to give you, seller, to take a look at this and make a decision? And the boilerplate or default here in the purchase agreement is for us to leave the offer out there on the table for 3 calendar days after the buyer's signatures are on it. So basically, it would say, hey, we're going to lob this over to you as a proposal. We're going to hit this over in the net to you as a proposal, and you have 3 days to decide whether to accept it, counter it, reject it, do whatever you want with it. That would be the default. Well, that's a long time, 3 days. So even though that's the default here, most Bay Area real estate agents try to shave that number down a bit. Not give when you're writing on behalf of a buyer, to not give them a full 3 days to spend thinking about whether or not they want to go ahead with an offer. So generally, kind of customarily, as a rule of thumb, I would say, we usually give the other side something like 24 hours to review the offer. I would say that's generally what most agents do strategically. So you'll see that I wrote this mock-up offer on June 27th, 2024. So let's pretend today's June 27th and we're preparing the offer. And I'm giving, in my example here, I'm giving the other side until June 28th, at around the same time of day, that I'm sending them the offer. I'm giving them about 24 hours to make a decision about whether or not they want to move forward with this. At which point the offer will expire after that date and time, so that I'm not leaving this thing out on the table for a long time so that sellers can think a lot about it, maybe shop it around. And by shop it around, I mean maybe the seller's agent, with 3 days to consider an offer, might talk to people in their office or talk to people out there in the market and try to find a better offer. We're not leaving up this opportunity for us to get kind of beat out by somebody else, but we're still giving a reasonable amount of time, because we're again trying to appeal to the seller to choose us, to choose our offer. So we don't want to be unreasonable. We want to give them enough time to look it over, but not so much time that we shoot ourselves in the foot. So about 24 hours is about custom. The next line in the purchase agreement is initial deposit amount. The initial deposit amount you'll see that I have filled in here is 3% of the purchase price. So these two numbers actually always correspond with one another. When you fill in the percentage here, it'll auto-populate what that means for your purchase number. So in our $1 million purchase, when we fill in 3%, that equals out to $30,000, and that's why that fills in here. I actually chose $1 million because it's the easiest number to work with for demonstration purposes. So this initial deposit that I have written as 3%, well, what is it? So when you're having initial conversations with your client about their purchasing ability, about what they're looking to purchase, what their goals are, they're going to do certain things to get prepared. And as I said, one of them is to talk to a lender about, what the financing will look like. Most buyers will have a down payment amount. They'll have money saved, that'll be their down payment to purchase a property, and the rest of the money they're going to be getting from a bank. And I would say, generally speaking, and in my example today, lots of folks have about 20% of a purchase price in their bank account that they're ready to put towards the purchase of property. Let's just use that number because it's used a lot it happens a lot, 20%. If a client has 20% to put down, then the other 80% is going to come from a bank. When we're having these initial conversations with our client and they're talking to lenders and they're preparing for how they're going to purchase a property, they're going to need to know that they're going to have that 20% or whatever they're putting down ready, available for the purchase, along with any necessary closing costs, costs that are accumulated through the purchasing process. They're going to have that all ready, because ultimately they're going to have to wire all their funds into an escrow account. They're going to have to give up all the money they've saved, to apply to this purchase, and they're going to have to hand it over prior to close. But there's a piece of that 20% or a piece of that larger down payment that not only do they have to come up with it prior to close, but they have to come up with it really early on in the transaction. And that's this initial deposit amount. This initial deposit amount is part of their down payment. It's just a little piece of whatever their larger down payment is that they have to make available, usually within the first 3 days of an accepted offer. They have to have it ready to go in their bank account to send over to escrow, either as a check or, to walk over as a check, or, and you should never do it. The client should always do it themselves, or wire from their bank over to the escrow. And the reason that I have 3% filled in here is because generally speaking, in the Bay Area, the custom is that buyers will put in about 3%, a portion of their larger down payment, about 3% of it as a good faith early initial deposit that'll go into an escrow account. And the purpose of the initial deposit is for the essentially for the buyer to have a little bit of skin in the game so that when they're writing an offer to a seller, they're saying, I'm gonna make this good faith effort to have some of my money, 3%, in an escrow account, ready to go, sitting there with that neutral party during the length of the transaction. That 3% also happens to be we're going to get to a paragraph later that talks about something called liquidated damages. Also happens to be kind of a capped out amount we can set when we're talking about the repercussions of defaulting on our agreement here. So if there are, so there's going to be 3% in this escrow account that's going to kind of be left there to keep everybody on task. It's going to act as a deposit. It's going to get applied towards the buyer's down payment at the close of escrow, but it's going to be in an escrow account early in case somebody, defaults and is unable to complete the purchase. There's already some money sitting there as a potential remedy. So when we're talking to our clients, remember that, one of the things they need to know is that while they have the 30 days or however long the escrow is to get their funds ready, their own personal funds ready, that they're usually going to have about 3% or whatever the deposit amount is ready within 3 business days. This is the default, or we can change that. Sometimes to be competitive, agents will change this to 1 or 2 days. And again, it's business days, not calendar days, so it wouldn't count weekends. It's one of the few places in our contract where we're counting in business days, not calendar days. So within 3 business days, the client will have this money ready to get it over to a escrow account. The next line in our purchase agreement on the first page of our first purchase agreement is this increased deposit amount line. The increased deposit amount it isn't really used that often these days, but it's a tool in our toolbox. Anything you see here that maybe I haven't filled in, usually if it's a tool in our toolbox that we don't see in every offer, that maybe we don't even see in most offers, I've probably left it blank. It's the kind of thing that doesn't have to get filled in. We don't have to use the tool, but it's here for those circumstances when we need it. And an increased deposit's a good example of that. So in all real estate transactions, just about all, we have that initial deposit amount that I have filled in up here, 3%. But there are some circumstances where a buyer may want to offer an increased deposit. They may say to the buyer, you know what, we're going to put in 3% within a couple of days, but we're going to put some additional part of our down payment money into the escrow account prior to close of escrow, maybe within 5 days or within 10 days, or maybe after we've removed contingencies where we'll put this additional amount in. Usually this paragraph or this line is used as a tool. It's used because maybe there's some milestone that needs to occur where a buyer wants to kind of incentivize the seller to do a certain thing. The seller, maybe the buyer wants to say, I'm going to add to my deposit. I'm going to give an increased deposit if some act has happened, if I'm satisfied with the removal of contingencies, or if and when you've completed some work that you said you were going to do, I'll put in this extra money. So if I left it blank, it's probably because we don't use it very often. You don't have to worry about it too much, but you need to know it's there. There's the ability to add in this idea of, hey, we're willing to increase our deposit. This next line, however, is in, just about every one of our purchase agreements that include financing. If our purchase agreement didn't, and it's the loan amount section. If our purchase agreement had started off here with $1 million and it started off as an all cash deal where we checked the all cash, we wouldn't need to enter in any information from a loan account about loan amounts. But as I've said, we're offering, our buyer client is offering $1 million, and it's not coming from all cash that they have on hand. Some of it's being financed. So in that case, which is most cases, we're going to have to fill in information about where that additional money is coming from. So in this scenario where our client is paying $1 million, but they're relying on some other entity to provide some of that money, we're filling in what that looks like. So I said that our example at $1 million is that our clients, Beatrice Buyer and Bob Buyer or whatever their names were, they have 20% to put down on this house, meaning they have 20% of $1 million or $200,000 to purchase a house with. Well, they're going to get the other piece of the $1 million, the other 80% from a bank. They've got a pre-approval from a bank who says to them, we'll give you the other $800,000 at close to purchase this property. But our client who's making the deal with the bank to get that money needs to know certain things about about what it's going to cost for them to, borrow that money and what it's going to look like, and they need to be able to share that with the seller in their offer. So there are other terms that we need to be clear about. So in this scenario, we're saying that the client, the buyer, is going to make their 20% down payment purchase with 80% coming from the bank, which is $800,000. We haven't checked any boxes over here, so we're saying that it's going to stay as the default, which is here in our grid is a conventional loan. They're going to get a conventional loan for $800,000 from the bank. If the lender told you that it actually wasn't a conventional loan, that it was going to be an FHA loan, FHA loans allow some buyers to put down a smaller down payment on a home. They're federally backed loans that allow buyers to potentially purchase a property with only maybe a 3.5% down payment. Sometimes a buyer will have like a 10% down payment and use an FHA loan. Well, if our lender tells us it's an FHA loan, we're going to check this box here. It's so that it's not a conventional loan. If the lender tells us that it's a VA or Veterans Administration loan, which sometimes requires, or doesn't sometimes, does require only, 0% down. Veterans who are qualified, who have served our country, have the ability to get these government loans that require 0% down payment. If we know from our lender that that's the client we have and that's how this is going to get structured, we check the VA box, etc. There are certain circumstances where a seller might be offering financing options for the buyer, where they're saying to the buyer, you don't have to go to a lender. Anytime that happens, you should call your broker and we should talk about it, because my advice to you is probably going to be that your client, the buyer, should talk to an attorney about helping structure any seller financing. It doesn't happen very often, but beware that if you have the suggestion come up, maybe a seller is offering financing and your buyer wants to take advantage of it, call me or whoever your broker is, and we'll discuss it. And we'll probably ask you to loop your client in with a lawyer about it. But generally speaking, most of these loans are going to be either conventional or they're going to be a FHA loan or a VA loan or something like that. So in my example, we've said that it's an $800,000 loan, 80% purchase price. It's conventional. We've left it that way. And we've left that we have an option here of a fixed rate, or if we check a box, an initial adjustable rate. In most scenarios, we've got fixed rate loans, so that's what I've left here. Initial adjustable rate loans are loans structured usually for a shorter time period. They're usually reliant upon an index with changing rate amounts over time. They can, some clients might find a rate advantage to getting an adjustable rate loan. But in most cases, I would still say that right now we're seeing fixed rate loans, so I've left it that way. So we're filling in some information, and you might be thinking to yourself, if you're new to real estate, how do I even, what I'm filling in here? And remember from earlier, we're working in partnership with our client's lender. We're not expected to be the expert when it comes to something like financing. We're expected to have the right conversations, make sure that we're getting accurate information, we're talking to the right person. But if our client in this scenario has a lender that they're working with, we're going to ask them these questions when we're structuring this. So in most scenarios, it's going to be a fixed rate loan. and not an initial adjustable. We're going to have conventional financing. And then we get to this piece here that says not to exceed. I filled in the number 7% when I was writing up this mock-up somewhere in June, probably. This is where we're going to fill in a cap of the loan amount that we're expecting, that our client is expecting to get from their from their lender. So, I mentioned that there's a conversation that's been had between buyer and lender about, that involves a pre-approval about what the buyer can afford, about what the rates are going to, about what they're borrowing, how much they're borrowing, what their down payment is. But part of that conversation with the lender is also going to be like, what did interest rates look like, and what kind of interest rate can our client expect in this purchase? So prior to writing this offer, when we're having our consultation with our client and the lender, we're going to be asking the lender, what does that interest rate look like? And we're going to have that discussion with the lender and our client. And if today's rates are somewhere around 6.5 or 6.75% for that client, and the client is satisfied with the loan option available to them, then we have to enter in a not to exceed amount. And basically, what we're signaling to the other side is, our client is going to, in good faith, look for a loan that is structured in a certain way. That, they've been to a lender who's going to give them a pre-approval, who says they can do this certain kind of loan. And part of what that loan is going to look like, or what the lender is going to tell us, is what kind of interest rate we're looking at. And we want to cap it somewhere, because day to day interest rates can fluctuate. They usually do fluctuate day to day. But day to day, they usually fluctuate just a little, but there's always the potential that maybe they'll jump a whole lot. And we want to create a cap just in case interest rates do something dramatic or unexpected. If the economy takes a dive tomorrow, we want to have protected our client by building in a cap based on the rate that is acceptable to them today. So in my scenario, I wrote 7% because, in this hypothetical, we've talked to the lender. They've told us that rates today are at, 6.8%. We can build in a little wiggle room because rates do move a little bit day to day, but we want to create a cap somewhere so that our client isn't locked in if rates jump to 8% tomorrow, or 9%, or 10%, because of some huge economic event. It's a safeguard. We're saying to the seller, this is the offer we're making, and it's your expectation for us to move forward. We're not, we're limiting it. We're saying that only if we can get the kind of loan that we have in our contingency, the loan that we're outlining here. So build in and not to exceed amount. A lot of agents leave this blank, and you should really build it in. Maybe add a little bit of a buffer from today's rate, 1/4%, an 1/8%, but build something in there to cap off the expectation. The next thing that this loan amount section addresses is points. There are occasions where a buyer might be offered by a lender the opportunity to buy down an interest rate. They may be told today's interest rate is 6.8, but if you pay for some of the loan up front, if you pay for what we refer to as a point up front, and a point is usually like 1% of the loan amount, maybe I can get you a better rate. So there are circumstances where a lender can agree to take some money up front by way of a point in order to get the client a better interest rate. I left it blank here because we're not seeing a whole lot of points being added. But again, this is something that would happen in conversation in conjunction with the lender. It's a decision that the client has made by finding the best advantage with a lender for the loan product that they're purchasing. But if the client or the lender does indicate that they're going to be buying a point, you need to let the seller know in the offer. I mentioned that the model that we're using here is a conventional loan, but that there are occasions where our client may come to us with an FHA loan or a VA loan or some other kind of loan program. If that's the case with an FHA or a VA loan, there's a opportunity here for the buyer to signal to the seller how long it'll take them to get a list of required repairs over to the seller. And the default is, you're saying within 17 days of acceptance of this contract, I can get you any required repairs over from the lender. So what does that mean? So in conventional loans, generally speaking, they're not built with the same kind of requirements that and Lynn, I'll answer your question in a second. And Kim, thanks for joining us. Um, uh, the in the loan amount section here, when we're talking about FHA and VA loans, uh, there are certain requirements that come along with those specific types of loans. So well, while the conventional loan might not have requirements, the FHA loan and VA loan might have requirements that say a roof be in good condition, or that the property have a working stove or refrigerator. Because these are government-backed loans, that they're partially funded by the government, because they come with these low down payments. There are certain expectations that the lender may require. There are certain things that the lender may require in order to make the loan. And in those circumstances, we need to be able to tell the seller, what they can expect. So here it says if FHA and VA is checked, if we find out that there's an overlay or an additional requirement about condition of the property, that we're going to let you know within a certain amount of time. And you'll see here the default is 17 days, but this is only applicable for those loan types, and you'll have to consult with the lender about a reasonable time frame there. And I promise we're almost done with a lot of the boring, if this is boring, numbers stuff. The first page is heavy with the numbers that we're tailoring for the offer. And we're done with a big meaty piece of this whole class when we're done with this page, and we're almost there. So the next line on this first page of the purchase agreement that deals with the numbers for purchasing the property is this additional financed amount section. So you'll see, if you look carefully, that it kind of mimics the section above that dealt with interest rates and points, and whether it's a fixed rate or not, whether it's a conventional loan. You'll see that this loan amount section and this additional financed amount section, they kind of mimic each other. You'll see that I filled in the loan amount section here because our client is dependent on a loan. And I said that my mock-up here is going to be the most universal look at purchasing a property, what we deal with the most, what's the most common. We don't really, generally speaking, these days deal with that many offers that require multiple loans. But we did, for a long time, we had a lot of purchases that maybe had two loans involved. And we still see them, often enough, where there's a first and a second loan that's needed, where the lender needs to or mortgage broker needs to structure something in a certain way where, we'll be getting like $600,000 from one party, and that'll be our first loan. And then we'll get an additional 200 from another lending institution for our second loan. There are occasions where we need this additional finance amount because maybe our buyer client is relying on two sources for their lending. And so we have this here ready to go as a tool in our toolbox for those occasions. But and we're just it's gonna kind of mirror the top part here. We're gonna write the specifics of that second loan down here in this additional financed amount section, and we're gonna indicate some of the nitty-gritty of it. But for our purposes, we're building an offer where our client is putting 20% down, they're getting 80% from the lender, and that's it. So let's finish off the page here. So we filled in all this info. Before we finish the page, I'm going to just do a recap. We finished all this info in our first page when we're tailoring this offer. We've said that our client is offering $1 million. It's not all cash, so they didn't check that box. They're prepared to close escrow in 30 days. The offer is going to expire tomorrow at 2 p.m. or whatever the this day is we fill in here. The initial deposit amount is going to be 3%. That's pretty customary in our market. That means that 3% is going to get deposited by our client, the buyer, into an escrow account right away. And it gets applied to their down payment later. There's going to be no initial deposit in our mock-up offer here. Our loan from the bank or lending institution is going to be 80% of the purchase price. We're going to get an interest rate that's not going to exceed 7%. It's going to be a conventional loan. So we're kind of coming down to the bottom here where all the math should start to work out. So if it's an 80% from the lender, it's $1 million purchase. So the lender's going to come up with 80% of $1 million, which is $800,000. It means that our buyer has committed to come up with $200,000 for the purchase, the remainder, right? 20%, and the remainder for the $1 million is $200,000. Well, we've said that they've already put part of their down payment down in the very beginning in the form of a deposit. They've put $30,000 down. So if we take the $200,000, that's the 20% that our client is going to have to come up with from their own money to purchase this property, and we minus the $30,000 they've already taken to their bank out of their bank account and sent over to escrow, we get left with the remainder of what our client is going to need for their purchase in terms of down payment. That's $170,000. So you see, everything starts to calculate and work out, and our zip forms are, where we fill this out, our forms library where we fill this out, there's going to be some auto calculating of math. Once we've entered in the $1 million, once we've indicated $30,000 of that is going to come up real upfront, once we've added that $800,000 is going to come from a lender at the end, well, then it's going to auto calculate the math of what's left. And here it's $170,000 purchase price, which makes our total $1 million. So that's the first page of the purchase agreement. And when we talk about this class and working in this grid where we're going to tailor it for our specific client, for the specific property, what they're willing to buy, what they're willing to pay, all the rest, we're done with a lot of the money, the real basics of what the offer is going to look like in terms of what they're offering monetarily for the property. But then we have to get into some of the other terms of the offer, some of the other things that we're proposing that are very specific to this offer. And that's where we get into pages 2 and 3 here. Before we do, let me see if there are any questions about page 1 where we're going to talk about this offer amount. First, I'm just going to answer Lynn's question in the chat. It was, what would be the reason to do a specific date of close versus standard 21 or 30 days? So I set up here that, we'll usually just fill in 30 days or maybe 21 if we want to be competitive, or 28 if we want to be competitive, but we have the option to fill in an actual date. And Lynn is asking, where would the advantage be there? There are occasions where a buyer may just have a lucky number, maybe the property was supposed to close in 30 days, which would wind up being November 9th, but the buyer loves things to happen on the 11th. Their birthday is on the 11th and they want it to close on the 11th. There's one reason. Maybe there's a holiday that's coming up, or maybe the client has to drive his kids back to their college dorm 30 days from now on November 9th. So they say, I would rather us just close a couple of days after that on the 12th. And they want to really get really specific. So I don't know that there's a specific advantage, Lynn, but there are circumstances where somebody might just prefer to write in a specific number, and they have that option here to do that. So that's the idea. But it's good questions, because the whole, why are we given this option? There's no real strategic reason there, but it's a tool. But I like that you're kind of starting to think about the offer. One line that I kind of glossed over here, or just went right over, that I should bring up, is that there's this occupancy type line. And I didn't have to do anything specific here in my mock-up presentation, because I'm writing for the most common offer we write. And the most common offer we write is for a primary property. Most of the time, we're working with a buyer that wants to move their family or themselves into a property that they're purchasing. And that's a primary purchase. But there are occasions where we're working with a buyer who's buying a second home, maybe a vacation home. There are other occasions where a buyer is not buying a second home or a first home. They're buying something that's simply and purely going to be an investment property, something that they're going to yield some kind of investment funds off of, a multi-unit property or something like that, or a home that they're going to rent out. When we know that a property is not a primary, so in this case, we left it as is because that's the default primary. When we know something is secondary or an investment, we have to check that box because it changes things for the lender. The lender has certain criteria that they have to work with. And it changes maybe the consideration from the seller who's going to be viewing the proposal. So we have to be accurate and tell our client, tell the other side, we have to check the box if it's secondary and investment property. But that's the initials, the basics of page 1 of the purchase agreement. And now let's get to page 2 of the purchase agreement. Like I said, we've dealt with a lot of the essentials around the monies of and what's being offered, but there's a little bit more to iron out in regards to funds, and there's the specifics of things like contingencies that change from deal to deal or transaction to transaction. And we're going to start dealing with that here on page 2. The first thing that we're asked is, are there going to be any credits, seller credits, to the buyer made in this transaction? So the buyer is offering to purchase property for a certain amount of money. They were offering to send their own money over, get the lender's money over before close. But there are occasions where maybe as part of the transaction, the seller is willing to kind of throw back some money as a credit at the close, usually. So has that been communicated to us? And if it has, do we need to fill that in so that it's clear in our offer? This line is generally not used unless there is this very specific reason to do so, that either the seller has indicated that they're willing to give a credit towards something like closing costs. Closing costs are those extra monies outside of down payment and purchase price and all the rest, those extra monies that both the seller and a buyer have to come up with just to make the deal happen, to pay off things like escrow fees and the lender fees, and to prepay or pay back insurance amounts, prorated insurance, to have money for prorated property taxes. It's those extra costs that come with purchasing a property. That's what a closing cost is. Sometimes the seller is willing to make a credit towards the closing costs, those extra fees and dollar amounts that are acquired in a real estate transaction. Generally speaking, I would say, 9 times out of 10 in most of our traditional markets, the seller has, over the last decade or so, had a lot of control because there's a lack of inventory or not a lot of inventory, and it's just been more of a seller's market. They've had a little bit more leverage and they haven't offered credits up front. But sometimes a seller will say, you know what, I recognize that that roof needs repair and I'm willing to make a credit. You can even write it in the offer that the seller is going to credit back some money towards closing costs at the end of the transaction. And you would fill that in here. Any money that a seller is willing to credit back has to get approved by the lender for the buyer, though. So if you're going to ask for a credit here towards something, first of all, it may make you less competitive unless the seller has told you that they're willing to make a credit. We're always thinking when we're writing an offer for a buyer, how can I be competitive? And one of the first places we can shoot ourselves in the foot when we're representing a buyer is asking for too much from a seller. They may not even respond to us if we've just unreasonably asked for a big credit or something like that. So first, make sure that a seller has offered a credit, or that it's not a competitive property. And second, when you're dealing with a credit, your buyer, if they're working with financing or a lender, they have to make sure that they're allowed to get the credit, because a lot of lenders will have caps on the kinds of credits a buyer can receive. Because remember, the lender has crunched all the numbers to get an approval for a loan based on a buyer's ability to purchase. And if a buyer is getting extra money from somewhere else, like from a seller credit, the lender needs to be made aware of that, and it's going to kind of come into their calculations, and the lender is going to have certain federally required good limits to what a buyer can get in terms of credit. A lending institution may have it. I usually, or in the past, it's usually been something around 3% is as much as the lender will allow in terms of credits from another party towards a buyer. So If there's a credit that you need to throw into a contract because the seller has indicated they're willing to make it, fantastic for the buyer, great, put it in, but first make sure that it meets the lender standards, and you would fill it in here. But you'll see in my example, we don't have one because they're kind of rare. The next line we have here is additional financing terms. So there's this kind of catch-all that I've left blank because we don't use it very often. If there's some other specific element that we need to fill in about how the loan is going to be structured or what's available, we would do so here. So if the lender says to you, yeah, there's going to be this loan has got to get structured in a certain way, and we need to convey that over to the other side, we're going to write it in here. Um, or anything involved with lending that we need to communicate is a new term we put in here. We don't use it very often. The next line is 3G3. Okay, so I've talked a lot. I've just talked about credits that a seller may make in a real estate transaction. And traditionally, those credits would be for things like fixing the roof, fixing a deck that needs repairs, or there'd be some other reason a seller wants to kind of throw money back towards a buyer at close of escrow, as kind of a concession for something. Well, very recently, as I'm sure most of you are aware, a lot has changed in the real estate industry. Traditionally, or in the past, sellers and listing agents, the seller's agents, have pre-negotiated commission amounts that are going to be shared with a buyer's agent. That's kind of how we've done real estate for decades. A seller will get a listing agreement. A seller's agent will get a listing agreement. In the listing agreement, the seller would indicate that they're willing to pay a certain commission amount, and that they're allowing the seller's agent to share some of that commission amount with a buyer's agent. And as most of you know, that's just recently changed. We're asking all of you, all the new agents in real estate, and actually all agents, to go out when they're representing a buyer and negotiate a commission to be paid directly by the buyer in a real estate transaction. The commission dynamic has changed a lot. Sellers get a commission, sellers agents get a commission agreed to with their seller for themselves as a seller's agent. Buyers, before represented buyer, get a commission agreed to with the buyer, and they get their own form on a buyer representation agreement saying that that buyer is willing to pay them a certain amount. But there's still a lot of circumstances where a buyer can't come up with that money. So, they have just enough to put their down payment in. They have just enough to make the purchase. They're squeezed and they don't have extra money to pay their buyer's agent. The buyer's agent has negotiated a buyer representation agreement with their client, but they've had a client. In many cases, they'll be having conversations with their client as a buyer's agent that they're going to ask in the purchase agreement for the seller to take over the buyer's obligation of a buyer representation agreement. So when a buyer and their agent have had the conversation, and a buyer says to their agent, I don't have enough money to pay you, but what I'd like to do is structure an offer where we're asking the seller to pay my obligation to pay you. We're going to check this box here in 3G3, and it's going to be something like that credit we talked about in the previous line. So the credit that we talked about in the previous line is a more generalized credit. It's a more traditional credit that we'd be using towards electrical work or a roof or something like that. But we've got this newer line that was added just a couple of years ago that says, seller, you know what? I'm also asking you, when I check this box, if you'll give me another kind of credit as a buyer. And this other kind of credit or concession that I'm asking for as a buyer is I'm asking that at the close of escrow, will you also take over my obligation to pay my buyer's agent? And if this is checked here, we're saying we're going to provide you a form, seller, called an SPBB, seller payment to buyer's broker. We're going to provide you with that form, and it's going to tell you outright what it is that we'd like you to pay to our agent. It's going to tell you what it is that we've already pre-negotiated or agreed upon with our agent to pay them in a buyer representation agreement. And we'd like you to take over that obligation. And what we're seeing in real estate transactions ever since our rules changed is that most, I would say, buyers seem to be taking this approach. They seem to be asking right here in the purchase agreement for the seller to, as part of and one of the terms of the agreement to take over their obligation to pay their agent. So when you're working with a buyer nowadays, you got that buyer representation agreement in place, and your buyer has told you, let's ask the seller to pay for it. You're going to check this box here. When you're representing a seller and you're looking at these contracts with your seller client, because remember, like we have to look at this from the other point of view. We've been talking a lot today as though you're the one preparing the offer because generally newer agents are working for buyers, working with buyers. And also, you need to know the fundamentals of how to fill this out. But there are going to be occasions where you're on the other side of the transaction, where you're representing the seller. Somebody else has filled out this document with their client. A buyer's agent has filled this out with their client. And you have to sit with your seller client to review what's being proposed. Remember, when you're representing a seller, to look at this line 3G3. You look at every line, be really careful about the terms of the agreement. Be careful of what's asked of your seller client. Be careful to make sure if there's a credit being asked for that your client is aware of it. And be careful if your client is being asked to take over an obligation that your seller client is clear that some of their proceeds are going to go back out at the close of escrow to pay that other agent. So just be really careful. Always have thorough conversations about what these lines mean and what it obligates either party to. When this gets checked in a purchase agreement, it becomes another term of the agreement, just like the purchase price or a contingency. The seller, if they put their signature on this agreement as is, they're just agreeing to go ahead with it exactly the way it is. If a seller reviews this purchase agreement and they don't like $1 million purchase price, they have to counter and say, no, we don't want to agree to $1 million. We're attaching a counter and we want $1,050,000. In the same way, if a seller sees this and they're okay with the $1 million, but they don't like this clause here, this paragraph, this term saying that they're expected to pay the buyer's agent's commission, they have to counter it out. They have to say, okay, we've reviewed your offer and we're not completely satisfied. We've got a counter offer attached because we want to strike that one term out where you're asking us to pay your buyer's agent. That could happen, and we have to kind of keep negotiating there until everybody comes to agreement or we can't put the deal together. But we have this ability now to add in the request for a seller to pay the buyer's obligation to pay their broker. The next line in our purchase agreement, and after this page, I'll ask, write down if you have a question and we'll get to it, or even after this section. The next kind of bit of housekeeping here, or a term that we're including to kind of make sure we're all on the same page in our proposal is how are we going to verify certain things on behalf of the buyer? Like if we wrote an all cash offer, how are we going to verify that the buyer has all cash so that you seller that we're proposing this to feel comfortable moving ahead? And the boilerplate or default here is that we're going to attach something to the offer that verifies that the buyer has the ability to make that all cash offer. Our mock-up here was that our client actually isn't writing an all-cash offer. They're writing an offer that depends on some financing. But if this had been an all-cash offer, our boilerplate or default is that we're going to be able to prove it with the offer. We're going to give you a piece of paper showing that our client has the cash. The next line is verification of down payment and closing costs. It's more applicable to our mock-up here. Our mock-up says that we're going to get a loan. Well, I'm sorry, the next line, verification of loan application, is more applicable to our mock-up here because we're saying we're getting a loan, we have a lender involved, we're going to attach a pre-approval. In circumstances where there's a loan, we're also going to have to verify down payment and purchase price. So you see these three paragraphs, they're saying, and the default in each of them is that we're going to attach something to the offer. They're each saying, how are we going to verify some of the terms you found there on the first page? The way that we verify all cash, for instance, would be if our client has $1 million to spend and they don't have to depend on financing, we're going to need some kind of bank statement or statements from another financial institution or their own family trust or whatever it may be that says here this person has $1 million and it's ready to go to purchase this property. It's going to have to be from a reputable institution that a seller is going to feel comfortable looking at the letterhead and the document and feel satisfied. So attach that pre-approval. If the client is relying on a loan, we're going to be, as verification of down payment and closing costs, we're going to be providing something like a lender, like a bank statement that shows that our client has the $200,000+ needed for the down payment and closing costs ready to go in a bank account. If it is if there's a lender, like in our mock-up here, we're going to have that pre-approval letter. And again, the default is attached with offer, and I usually would just leave it exactly like that. If you try to change this to, hey, I'll provide you with proof 3 days later, you're most likely going to lose out in any competitive situation. A seller and a seller's agent want to see up front that you have the ability to move forward. So I would say leave it as I will attach it to the offer and make sure you have that all lined up to send in with your offer. When we get into this verification of loan application part here, you'll see that the default is attached to offer, but you'll see that there's a couple of additional lines over here that we need to kind of clarify some things. You're asked, okay, that loan application or pre-approval, that lender application that's been submitted, is it going to be what do we have that we can attach as proof? Or do we have a pre-approval, a pre-qualification, or a fully underwritten pre-approval? And I will say that even though there are 3 options on this page, there's only really 2 options here if you want to get an offer accepted in most of our markets. The 2 options that are generally considered acceptable are either a pre-approval or a fully underwritten pre-approval. A pre-approval means that the lender has had an opportunity to go through the seller's finances and vet them to some extent and knows that they're employed and knows that they have, has looked at W-2s and knows that they have the ability to buy and they feel satisfied and can write this thing called a pre-approval letter. A fully underwritten pre-approval is even better than that. It means that the lender has had the ability to look at the buyer's finances. They've looked at W-2s. They've verified some employment. They know that the client has certain funds and feels really confident and has even has even run some of these numbers by the pre-approval, the underwriting department in their bank, that they've gotten the ability to say, we can get this underwritten. When I say that there are 2 of 3 of these options that are acceptable, the option that's not acceptable, generally speaking, because it's going to make you really almost completely uncompetitive, and a lot of sellers and their agents will just laugh at, is this pre-qualification option here. The difference between a pre-qualification and pre-approval is the pre-approval, which is the good one, is when the buyer's been vetted by the lender, where they've had to prove some things about their ability to purchase. Pre-qualifications are given out when a buyer can breathe. A pre-qualification is not even worth the paper it's printed on. A pre-qualification really is just a letter from a bank saying, I've had a conversation with this person, and from what they tell me, they should be able to purchase this property. It doesn't hold a lot of weight. There's hardly any vetting that goes along with one, and you're going to probably lose out on the property with your client if all you've received from a lender is a pre-qualification. So if you get a pre-qualification letter from a lender, push back and say, if we're gonna make this happen, if we're gonna get an offer accepted, we need more than a pre-qualification. We need a pre-approval, or even better, a fully written under pre-approval. Because sellers and their agents are going to scrutinize what they have in front of them, and they're going to say a pre-qualification doesn't really tell us anything. So get your proper lender verifications in advance. Okay, before we get into some of these other terms, I just want to see, we've talked about seller credits and we've talked about how to prove the buyer's assets. Does anybody have anything that they want to ask about seller credits, or ask about this idea of asking the seller to take over the buyer's obligation? Sunil says, so far so good. Good to hear that. Anybody else? I'm going to give it like 5 seconds. Otherwise, we're just going to keep moving. Anybody want to jump in? Getting a thumbs up? Okay, we're gonna keep moving on. So we're starting to get our offer filled out. We're starting to kind of get it figured out. We've talked about how much we're going to offer, how long the escrow is going to last, how it's going to be structured, that where we're going to get the money from. We've talked about whether there's going to be certain kinds of credits, whether we're asking the seller to pay the buyer's obligation to pay their agent. We've talked about how we're verifying some of the monies that we intend to put together as the buyer. And then we get into some a little bit more housekeeping, and then we're going to get into something called contingencies, like some other little safety nets that we're building in on behalf of a buyer in a real estate transaction. Let's deal with these two little pieces of housekeeping before we get into this larger concept of contingencies. These two other pieces of housekeeping are the first one is final verification of condition. Well, a buyer has the ability prior to close of escrow to go back to the property. This isn't about inspections. It isn't about the investigation of the property. It's at the very end, we have this ability to do something called a final verification of condition when we're a buyer. And it's usually sometime within 5 days prior to close of escrow. You'll see the boilerplate here is 5 days prior to close of escrow. The buyer has the ability to go back to the property and just make sure that it's in substantively the same condition that it was in at the time that they wrote their offer. That no walls have come down, that no pieces of the property have changed from being the property that they wanted, that they wrote the offer on. It's a basic ability or time to walk through the property and make sure it's in the condition that is expected. It's not a time to renegotiate. It's not a time for an investigation. It's not a contingency. It doesn't allow you to back out of the transaction. It's a time to make sure that the property looks the way that it's supposed to look. There are occasions during an investigation contingency period, however, that we will actually point to this verification moment as the time when we expect certain things to be done. So we're saying within 5 days of close, we are going to be able to do a final verification. We want the property to look like the property that we wrote an offer on. Also, if there's something that we negotiated during the escrow period that we expect to be done at our final, by our final verification, that's our marker. Like we know that 5 days before we've said, maybe in our negotiations that we want a deck to be repaired or electrical to be done. Oftentimes we'll use that day, that final verification day, as the final marker day for some agreed upon repair to be done. But usually, and for the most part, it's just an opportunity for our client to walk through one last time and make sure things haven't substantively changed. That's what we mean by final verification. And then another little housekeeping piece here is this assignment request. Again, I've left this boilerplate, or I've left it as default of 17 days. Here we're being asked if an assignment needs to be made, when are we going to let them, what's the last day we can let a seller know? And it says by 17 days after acceptance, we have to let a seller know if there's going to be an assignment made. What's an assignment? And every real estate contract, all of our purchase agreement contracts are assignable, meaning the buyer who is on the contract on that page one, Bob buyer, Beatrice buyer, they have the ability to assign over their responsibility in the contract. Doesn't happen very often, but does happen sometimes. What does an assignment look like? Well, if I, Beatrice buyer, and Bob Buyer say that Bob Buyer is not going to be one of the buyers anymore. Just Beatrice, the wife alone, is going to purchase the property. Well, then I have to assign over this whole contract, all the obligations of the buyer. I have to sign it over just to Beatrice. I have to take Bob off of the agreement. That would be assigning Bob and Beatrice's obligations over to Beatrice alone. That's an example of an assignment. Another assignment example would be what happens if Bob and Beatrice are buying the property according to the purchase agreement, but sometime before day 17, they decide that they want their trust to purchase it instead. Maybe they have a family trust, the buyer, Bob and Beatrice buyer family trust. Well, we want that to be the actual buyer rather than Bob and Beatrice as individuals. Well, then we're going to assign it over to the Bob and Beatrice trust. And it's really basically changing out the buyer. So there's no longer Bob and Beatrice as individuals purchasing the property. It's by a Bob and Beatrice trust. Maybe Bob and Beatrice who are on this purchase agreement, maybe they have a company called the Acme Bread Company. Maybe they want to have the Acme Bread Company buy it instead. Well, they're going to sign over their interests. They're going to sign over their obligations to Acme Bread Company, and that would be an assignment. Those are the most common kinds of assignments. Sometimes, Bob will be buying it with Beatrice, and Beatrice's credit will be terrible, and they'll decide that they're going to take her off of the purchase, and it'll just be Bob purchasing. But there's one other kind of assignment that happens, and that's when a wholly new person is going to be assigned the obligations and the interests highlighted or defined here in this contract. That would be if Bob and Beatrice are purchasing the property according to the contract, but somewhere along the way, they realize they can't or don't want to purchase it. But maybe Bob's brother or cousin or some other person wants to take over the purchase. That other person, whoever the assignee is, still has to do everything that is agreed upon in this original agreement. They still have to take over all the same obligations. They have to come up with the same kind of down payment. They have to get the same kind of loan. They have to deal with the same contingencies, etc. But Bob and Beatrice may want to assign it over to that person. That does sometimes happen. That kind of assignment would need the approval of the seller because it's not just assigning it to your own wholly owned entity like a trust or company. It's assigning it to a whole new person. It would need the agreement of the seller, the buy-in of the seller, and you'd need to let the seller know within 17 days. And then Sunil is jumping to the question, the good question here, which in the chat, which is there any form to fill out for an assignment? If there's an assignment request within the 17 days, again, it doesn't happen that often, but if there's an assignment request, we use a form called the Assignment of Agreement Addendum, and we have to present it over to the seller and request for assignment. So yes, Sunil, there's a specific addendum that you find in your car library that's called an AOAA, or Assignment of Agreement Addendum, and we specify how we're assigning over, or we'd like to sign over the contract. We're just saying we want to remove Bob, or we want to remove Beatrice, or we want to change the buyer to be their trust, or we want to assign it over to this wholly new person. We would do that within 17 days. We don't do them a lot, but that's a little kind of overview of what an assignment is. And we're saying in the contract, if there's going to be an assignment of any kind, we'll let you know, seller, within 17 days, or we can shorten that period here. And that's some, like I said, it's a little housekeeping, something that can happen in real estate transactions that we need to know how soon or late we're going to let the seller know. If we're going to take advantage of that mechanism, when are we going to do it? So that's a lot of the basics. And I've said that we've gone over all the numbers and how we're going to do the loan and some of the nitty gritty on how we're going to prove financing and all the rest. And we've done some of the extra housekeeping. Well, what are the other substantive parts of writing an offer for our buyer to purchase a specific property? Well, one of the major other elements when we're sitting down with our client to write an offer is, what kind of contingencies, buyer, do you want to see in this offer? What's a contingency? A contingency is a hey, but if kind of clause in the purchase agreement. Hey, we're going to offer you $1 million. We're going to structure it this way. Hey, but if we can't get the loan, we want a way out. Or hey, but if the appraisal doesn't work out, we want a way out. Or hey, but if we do some investigations and don't like something, we want to renegotiate, or we want to be able to bail out. The contingencies are this escape clause, essentially. They're this parachute or exit door from the contract for a buyer if they're unable to line things up in a way that is acceptable to them. And the kinds of contingencies we see in purchase agreements are, generally speaking, the big ones are the loan contingency period, the appraisal contingency period, the investigation contingency. and the insurance contingency that was recently added. These are the big contingencies that we add in as a hey, but if, or as a exit plan for the buyer, where they're saying, I put some money in as a deposit, but there are certain things I need to find out first. There's certain there's this ability to back out that I need where I want to be able to take my deposit with me. And those all have to have time frames involved, right? For a seller to be satisfied with moving forward. We have to signal how long we're going to need in order to accomplish some things to be sure that we're moving on. And after those time frames are up, we're saying, we recognize that our deposit is potentially at stake if we try to cancel the transaction. So let's look at contingency periods. You'll see the major contingencies that we have in this purchase agreement here. The first three are the loan, the appraisal, and the investigation. And you'll see that the default for each is about 17 days, saying I need a contingency for this loan period in order to satisfy myself that I can get a loan on this property. Not just a pre-approval, not just a letter from a lender saying that I'll probably be able to get it, but an actual loan in place. How long do I need? And the contingency boilerplate is 17 days here. You'll see in my example, I've tried to shave that down somewhat to 10 days. I can't really do that as a buyer or a buyer's agent without some agreement from a lender. This is going to be part of the conversation our client's going to be having with their lender. How long will it take you to get the loan really lined up where you feel confident, absolutely confident, we'll get it? In my example, I made it 10 days here. But again, it's in conversation with the lender. There will be circumstances maybe where you won't need a loan. Maybe it's an all cash transaction. Maybe that was what we checked on page 1. We'll be able to check here, no loan needed, no loan contingency needed. We don't need that back out plan. There may be circumstances where we're working with a lender, but they tell us for whatever reason that this is a high asset borrower, that this buyer is in great condition, and that they do not need the loan contingency. It's rare, but it does happen. And then in those circumstances, we'll, at the instruction of a lender, and preferably in the written instruction, meaning them telling you in like an email or something, go ahead and remove the loan contingency. You don't need it. Rare. Get it in writing if they tell you that. But in most cases, we're going to need some time in a finance deal to make sure that the loan will come through, that the lender, and we'd write in a certain amount of days. The contingency period says, certain days after escrow starts, after we have an accepted offer, we're going to come back to you as the buyer and actively remove our contingency. We're going to give you a document on, say, day 10 that says that we're removing that contingency, that escape route. To make you feel better, seller, we'll have this all lined up within this many days. On that day 10, we're supposed to give over removal. The contingency isn't removed until we give over the removal, though. It's not a passive thing. It doesn't just happen because the date comes. We have to send it over as the buyer's agent. If we don't send it over on day 10, the seller has to make a decision. Do I want to force them to send me over that removal? I want them to remove that escape route. I want them to give me the contingency removal they said they'd give me in this offer. They have a contractual obligation to give it to me. The seller has to actually send over a form called a notice to perform, which basically says you had an obligation to remove your contingency. I'm giving you this document that says you have to perform and give that to me within a couple of days, within 2 days, or I'm going to cancel as the seller. Sellers generally can't just cancel. But if a buyer hasn't performed because they've said they're going to do something within 10 days, the seller can then start the clock ticking with this notice to perform where the seller can say, I'm going to cancel because you haven't given me your removal. So really, basically what we're doing when we're filling in a contingency timeline is we're saying the buyer is prepared to move forward and get certain things done within a certain period of time. And if the buyer doesn't, they owe you this thing called a contingency removal. They're supposed to remove their ability to back out and take their deposit because of that, that specific contingency. And you, seller, if you don't get that from me, you can compel me or push me to do so with a notice to perform, and then you can go cancel yourself. So we have to be really careful because our timelines, we're making a pledge in good faith to do a certain thing as a buyer and a buyer's agent, and we have to meet our contractual obligations. So if we're going to fill in these numbers, we have to feel pretty damn well sure that we can meet our obligation here as a buyer or buyer's agent. So we're filling the number. The appraisal, similarly, is going to be information that we're going to need from our lender. We're going to have to ask our lender if there's an appraisal required, which there is with most home loans. How many days will you be able to get the appraisal done as a lender? They send out the lender, they request the appraisal. And where you think that we'll have the appraisal out and back in writing, and we'll be able to remove our appraisal contingency. At the point that an appraisal comes in, if it comes in low, we may have to back out, and we'll have that right as a buyer. Similarly, in the loan period, if we have 10 days to secure the loan, if we try in good faith to get the kind of loan that we said we were going to try to get, and we get a denial, we're told in writing by a lender that I cannot approve the loan that we said we could try to get and try to approve for you, I'm going to be able to back out of the transaction. If I still have my contingency in place and take my deposit. Similarly, with the appraisal, if you've gotten the appraisal report back and it came in low, if I have an appraisal contingency in, I can go back to the seller as the buyer and say, you know what? I said I'd purchase the property if it appraised. It didn't appraise, so we're back at the drawing board because I can either cancel right now and take my deposit, or you can try to negotiate with me about the appraisal. About what came in on this appraisal. If the appraisal came in low, that means the bank's only willing to offer to pay up to that appraised amount. So even though I told you I'd spend $1 million on your property, well, this appraisal came in low. I still have the contingency, which means I still have the ability to cancel and take my deposit. Do you want to renegotiate? Do you want to bring it down, the property purchase price down to the number that came in at this appraisal of, $950,000 or some lesser amount because the appraisal wasn't met? So the contingency gives you the ability to quit, cancel, renegotiate, or move forward if you want to move forward. This appraisal section says appraised contingency. What is the appraisal contingency? The appraisal contingency is going to cover the appraised contingency, the appraisal value. So it's going to cover the appraisal value. So you need to get this property to appraise at the value, $1 million that you're offering on it, or at a minimum at the minimum purchase price. So the appraised value is going to come in at the purchase price, that $1 million, and you can plug in a different number. And this was just added a couple of years ago. There are circumstances where, in conversation with a lender, a buyer may say, you know what, my lender is telling me that even if it doesn't appraise, I can move forward and I'll get the loan I need. Or the appraiser is telling me, even if it does, the lender is telling me, even if it doesn't appraise or it appraises a little bit low, that because of my financial situation, because I have all this extra cash in my bank account, I can still go ahead and purchase the property. So there are circumstances where, you may be bidding in competition on a certain property and you're bidding $1 million, which you think is a little bit high, and you think the appraisal might come in low, but the buyer has extra funds and the lender is comfortable with you saying, you know what, we'll still move forward if it appraises low. You can check this box and say where your threshold is going to be, and you can lower the amount so that it's not the value, appraised value. You can say the buyer is willing to keep moving forward if it appraises at $900 or $950,000, that number that's less than what we're offering. I wouldn't use this checkbox and add in a different number here unless you get explicit instruction from the lender and the buyer that they're comfortable moving forward and that they don't need to be covered by an appraisal contingency if it appraises low at like $900,000. So it's a tool. We don't use it that often. If you're ever going to use it and lower the appraisal expectation, it should be just because your client has a lot of extra money on hand and feels comfortable doing it. The other option sometimes is you'll see here no appraisal. There will be occasions where a lender will say, this is a slam dunk buyer and they have so much money in extra assets. We'll be able to make this loan no matter what. They don't need this to appraise. Or we already did some kind of desk appraisal, like, we did some virtual appraisal and we're not going to need to get an appraiser out to the property. Never check the box for no appraisal unless you're explicitly clearly told by a lender and hopefully in writing that they don't need an appraisal contingency. Otherwise, these contingencies protect our client, so keep them in. Similarly, the next kind of contingency that is one of the main contingencies we use in purchases is this investigation of property. That's our inspection contingency. That's what we colloquially talk about as our inspection contingency. But in truth, it's actually called investigation of property. We go around in real estate transactions all the time talking about, do we have an inspection contingency or do we need an inspection contingency? But actually, it's better than that in the actual contract. It's an investigation contingency. And what I mean by better than that is it's broader than just the word inspection contingency. The actual contingency is the ability to investigate. Inspections happen during an investigation contingency. We get maybe a pest inspector out to a property, a home inspector out to a property. But really, the broadness of this great contingency is that our client is given the ability, our buyer client, to investigate a property. And that means that they can ride by a property at night and see if they like the neighborhood. They could knock doors and talk to neighbors if they want to. They're allowed to investigate, to get to know the property in a deeper way than comes with just maybe hiring a couple of inspectors. Yes, that does happen, and that's part of the investigation. But our client, when they build in an investigation contingency, has the ability to find out more about the property that they're about to purchase. And they're saying that we need this amount of time to investigate the property, and I put in 10 days here. I've shaved it down from 17. And during that period, we, the buyer, will satisfy ourselves that we're happy going forward with the property in the condition that it's at. We'll get inspectors out if we need to get inspectors out. We'll look into whether the property's in the kind of condition we want it to be in. We'll investigate any way we want. And we'll let you know by that day 10 whether we're moving forward or whether we're canceling with our deposit. When that day 10 comes, we may come back to the seller and say, we've done our investigations and we've found out that there's some work that needs to get done that wasn't previously disclosed. We've done the investigations and the inspectors come out and says that it needs a new roof. Well, that wasn't told to us as part of the package when we were writing the offer, as part of the disclosure package. So we want to renegotiate. So it gives the buyer a little bit of leverage because they're able to say, I can walk away now with my deposit and cancel this contract. So at day 10, after they've done their investigations, they may decide, well, we're not happy with some of the things we found, but we actually also don't want to cancel. What we want to do is go back to the table and suggest that the seller help us out here and make some repairs. So the investigation contingency, at the end of the investigation contingency comes a choice. The buyer can cancel if they don't like something. They can move forward because everything they found out in their investigation contingency is peachy keen and they like the property and want to move forward. Or they can start to renegotiate. They can say, I want the seller to take over the cost of this pest inspection that we didn't know about, or do this other work. And the seller then gets to make a choice. They can say yes or no, or whatever they like. And then the buyer listens to the seller's decision and they say, great, I'll take that credit. Or if the seller said, no, we won't want to do anything for you, maybe the buyer says, all right, then we're going to cancel. It's a time that reopens up an ability for the buyer to have a little leverage to potentially cancel or renegotiate. There are a lot of offers that get written without any contingencies. And you have to remember when you're representing a buyer that that's the riskiest state you can be in. When you write an offer on behalf of a buyer, when the buyer is saying to you, I don't want or need any contingencies, well, if it comes to loan appraisal, you have to be damn well sure that they're able to get the loan or or don't have a loan that they need, because they're basically saying, if I can't get a loan, I'm gonna try to cancel this contract and I'm gonna have to hand over my deposit because I don't have a contingency. So it makes no sense to remove loan and appraisal contingencies if you aren't 100% sure you can come up with the money to purchase the house. And when it comes to investigations, we see a lot of properties where somebody will write an offer with no investigation contingency. But you have to be damn well sure then that your client wants the property, because anything they find out during the period of the escrow that changes their view of the property, they're going to have no way out without losing their deposit. So it's super important when you're talking about contingencies with your client that your client realize that this is their way out of a transaction where they can take their sizable deposit with them. Without contingencies, if you decide, buyer client, that you want to write without a contingency, you are jeopardizing your deposit. And when you come to me 2 weeks in and decide you don't want to buy this property and we don't have the necessary contingency built in to leave, you may very well leave your deposit. It's very important stuff that your client needs to be aware of. So um, never remove contingencies without a really thorough conversation. And if your client wants to remove all contingencies for some reason, let them know that it's really risky. It's against our advice because they'll have no way out without losing their deposit. And have them look at something called buyer non a contingent. Sorry, there's a form called a non-contingent offer advisory. I think you should be able to see it here. If your client says, I don't want contingencies or I don't need those specific contingencies, have them read this advisory and sign it. Because this advisory is going to say, you may be jeopardizing your deposit if you decide to bail out at any point. I'm telling you, I get more calls as a broker about clients who do not have a contingency in place, who then later blame their agent for not having this thorough conversation that they're putting their deposit in jeopardy if they don't have the appropriate contingency in place. So if you're newer, have really clear conversations with your mentor about what it means. Have really clear conversations after you've talked to your mentor with your buyer client about all of the risk in not writing in a contingency, and make sure you document those conversations and get non-contingent offer advisory signed by your client if they don't want to have a contingency. Sometimes a client will decide that it's the only way to be competitive. Maybe you'll hear that three other agents are writing competitive offers on the same property and they're not going to have contingencies. And sometimes a client will decide it's the only way to get the property. But boy, do you want to cover yourself to make sure that you have had really clear conversations with the client about what that'll mean to their potentially mean for their deposit. And boy, do you want to document that and make sure that they know that you don't think it's a great idea. But if it's the only way to get the property, they may make that decision. But cover yourself. Contingencies are removed with a contingency removal form. In the cases where contingency is removed with the offer, you're going to check the box that says that you're going to be giving a contingency removal over with the offer. Those are in those circumstances where, as part of the offer, you're saying we are removing the investigation contingency or we are removing the loan contingency. We don't need it in this transaction. So that's my spiel about contingencies. I mentioned the biggest ones: loan, appraisal, investigation. Another big one nowadays is insurance. Try to build in an insurance contingency whenever you can, particularly if you have any doubts that the property will get insurance, because property is getting denied insurance left and right. And you can't close a deal, you can't get a loan without the insurance in place. So be really sure your client can get insurance on a property. Otherwise, write in an insurance contingency away from the bailout. Um, is that okay? So Sunil asks, is there okay with you if you can give us a link to this agreement to keep as a template? Yeah, I did actually add it in chat earlier, but for people who joined a little later, it might not be showing up. Let's see if I can add it again. Sunil, there's a link. Oh, hold on. Let me, for some reason that's going to just Kim Lee. Let me put it in again. That's a link to all the documents I'm using in today's class. So if you can write in a contingency, write it in. Insurance is definitely one we need nowadays. I put 10 days in because I like to have contingencies. I like to have the protection for my client, but the boilerplate or default here of 17 days is a long time, and it's hard to compete and get an offer accepted with that long of an open period for a seller not knowing whether the buyer is going to move forward. So, if you can get an offer accepted with a more reasonable contingency period, like 10 days for your contingencies, fantastic. And you're going to have to decide on these numbers with your client by evaluating how competitive you need to be in certain circumstances. And there may be circumstances where you have to really shave these numbers down or remove the contingency, but make sure it's your client's decision to do so and that they understand the consequences. The last couple of pieces here in this contingency section are things like review of seller documents, review of preliminary title report, common interest developments. These are to review some of the documents that should come along with a disclosure package, all of the transfer disclosure statement and seller property questionnaire, things that maybe you aren't going to get for a couple of days into the transaction that your buyer needs to review. Build in a time period for your client to look at those documents. Oftentimes in our Bay Area market, we have disclosure packages provided up front. So we'll have a lot of these documents provided before we even write an offer. It is not technically required in a real estate transaction. Actually, the seller has 7 days, according to the contract, to get us those disclosures. They don't have to provide them prior, but it is our custom here to have a lot of that documentation available in advance. But whenever your client needs to review documents and wants some extra information, they should be able to build in a period where they can look at those documents. And that's what this review of documents, prelim, and common interest developments would be for things like HOA docs. Remember to build in the time periods. Review of leased and liened items, build in a time period if you know that there's solar panels, for instance. If you know that the property has some specific aspect that needs review, that deals with a leased or a liened item like a solar panel built in. So I went through the whole contingency thing, talked about some of the kinds of contingencies we have, but I skipped over something called informational access. And you'll see it's in our contingencies section, and it's right under investigation of property contingency. You'll see this in informational access. But the funny thing about it being in our contingency area and underneath investigation of property is that it says buyer's right to this informational access is for informational purposes and is not a contingency. So it's a little bit ironic, right? It's in the, or a little bit uh, uh, confusing. It's in this contingency section, but it's actually not actually used as a contingency. What it is a clarification of something that we need like a time frame around. And it's a clarification around a time frame of how many days into the transaction does the buyer still want the ability to walk around that property. And you're saying here the prior may give up their contingencies. They may give a contingency removal for investigation within 10 days. They may have satisfied themselves that they understand the property and are willing to move forward and from which point on their deposits in jeopardy if they want to cancel. They might do that all of that within 10 days, but they still want informational access, not the ability to cancel, not a contingency, not an ability to back out with their deposit, but they want to make clear with the seller, hey, we still want to be able to walk through the property. Maybe we want to measure the size of a wall for a couch, who knows? But we want some informational access. We want some ability to keep coming back to the property. And the boilerplate's 17 days. And I usually leave it at that. Doesn't guarantee the ability to quit, but it's something we can point to if we're in an escrow period and a buyer and a seller wants to deny us the ability to just walk through the property. So that's what informational access is. So now we're kind of done with our contingencies section. It's another huge piece of the pie here. So we want to make sure that we kind of understand what it is we're trying to tailor and agree upon here. Does it all make sense? Can I keep moving? Anybody need to jump in with a question? Gonna keep moving. Okay. So after we've built in our contingency periods, there's a little bit more that we have to deal with in our grid in these pages of the purchase agreement that we're writing at the time of offer. So let's look at them. The possession section. So most properties I'd say most are handed over at the time that the property closes from one seller to the buyer, and the buyer pays the seller for the property through escrow. The bank gives all the money is settled. The escrow deposits the seller's proceeds into their bank account. All of the nitty gritty is dealt with in the escrow period, and the buyer gets their keys, and then they move into their house. So most of the time, and that's when we record the property with the county at that close. Most of the time, buyer gets the property upon recordation at close of escrow. But there may be a time where a buyer wants to receive the property, later in the day, maybe 6 p.m. On that day, or they might want to receive it on another day. And they can indicate as much, but usually be out of time of recordation. There may be a time where the property is occupied by somebody else that's not the seller. Maybe a tenant is occupying the property. Maybe the buyer doesn't even intend to move in ever. Maybe if they're buying this as an investment property and it's occupied by a tenant. In those circumstances, maybe time of possession is not gonna, that we're not gonna take the keys and move in on the date that we close. Maybe instead all of that's gonna be agreed upon in a separate document. And in this case, the document would be something like a TOPA, and the TOPA is the Tenant Occupied Property Agreement. Maybe we're going to change this. We're going to say not upon recordation, but that we're going to occupy it on a different day. And if that's the case, we'll have a form called a TOPA attached. You'll see that later here in 3M3. In properties that are occupied by tenants, we're not going to take over the property right away. We're going to have this box checked. We're going to have this other form attached. We're going to talk about like what the leases look like and what the tenancy looks like and whether we're going to inherit those tenants, et cetera. And it's not going to be a straightforward, we take over the property on that day. This is only applicable when it's not the seller passing over the property. But there's another kind of possession or another situation that happens with possession. Sometimes it's not a time of recordation or the time of closing. Sometimes the seller intends to occupy the property after close of escrow. Sometimes the property and any units involved with the property will become available at close of escrow. But sometimes we'll have to check one of these other boxes saying the seller's not giving it over that piece of the property or that unit or that house for some days after close of escrow because maybe they need to occupy it for a little bit longer. There are occasions where a seller wants, as part of the deal, to be able to stay at the property after the day of close. After the buyer owns it, they want to stay at the property. Sometimes they just want to stay for a short period of time, under 29 days, and we use a form called a seller in possession form. And we make an agreement on that form that says the seller can stay there for another 15 days or 20 days while they arrange to get their stuff moved out or where they find a replacement property or whatever. And sometimes it's more than 29 days. When it's under 29 days, we use something called a seller in possession form. It's a short form. We say that the seller will be out, maybe 2 weeks after escrow closes. Maybe they'll pay a certain amount to the buyer in order to stay. Maybe they won't. But then there are other occasions where maybe a seller wants to stay longer. Maybe they want to stay more than 30 days. In those circumstances, a different form is attached. That different form attached is the RLAS, or Residential Lease After Sale. Debbie, thanks for coming today, and this will be recorded also, so you can watch the end of it in a recording if you have to head to an appointment. The residential lease after sale is for when the seller needs to stay for even longer than the seller in possession, the 29 days. They need to stay for 35 days, 40 days, maybe 60 days. That looks a little bit more like a lease. It's a residential lease after sale. It has terms that include, like, if there's going to be a deposit held, if there's a cleaning deposit, what happens to utilities. It gets more specific. It's a 5-page form, and it allows for the buyer to purchase the property, but the seller to stay a little bit longer. And that's what we would use these check boxes for. And I mentioned that sometimes the property is occupied by tenants, and we use this checkbox that tells us how that's going to work. So this is the possession area, tells us whether it's going to be occupied right away by the buyer once they own the property, or whether or not somebody else is going to keep occupying the property that is not the buyer. And then the last section on this second page deals with when we expect certain documents to be delivered and certain fees to be paid, et cetera. It's just a little more housekeeping, just of us keeping track of who's responsible for what and when. So when is the seller going to deliver all the documents they're required to give her within 7 days? We leave that as is. When is everybody going to have to sign and return any escrow holder provisions? When are we going to give them over the escrow holder over this purchase agreement? Well, that says within 5 days here. Time to pay an order for any HOA fees. Well, in certain communities, there's a homeowners association, and there are fees attached with ordering all of the homeowner association documents. We're saying here in the contract that the responsible party is going to have to get that done within 3 days. When are smoke detectors and water heaters going to be taken care of at a property? And in the contract, we're saying within 7 days, anything that needs to happen there happens. Usually it's seller responsibility, or it is seller responsibility, and they're going to have to get those things done within 7 days. This last line is evidence of representative authority. That needs to happen within 3 days after acceptance of an offer. So if we're buying as a trust or in some other fashion, and we've written that it's the Smith Family Trust that's purchasing the property on this purchase agreement, we need to give evidence of who the people signing on behalf of the Smith Family Trust are within 3 days. Um, Everybody at the end of every page will initial and that they agree to the terms of that page of the document. We're getting there, everybody. So the third page of this purchase agreement and the third page of this grid is really the last page of the grid. We have a couple other items that need to get taken care of in some of these other pages, but a lot of the bulk of what we're doing here we're almost done. We're in the home stretch. The third page is a lot of who pays for what and what do we expect included in the sale. So the first part is what's included and excluded in the sale. And there are certain things that a buyer may expect included in the sale that aren't attached to the property. They're not like physical pieces of the property. And we learned in our real estate classes that things have to be attached fixtures in order for us to assume that they're going to come along with the property. Well, there's a lot of things that buyers actually do assume come along with a property that aren't fixed. So we need to be explicitly clear in our purchase agreement that we expect to see them at close of escrow. Things like stoves, ovens, refrigerators, washers, dryers, dishwashers. So you need to run through this list with your buyer client when you're writing an offer with them. Check out the property, check out the MLS sheet. If the property has one or more of these items, make sure to discuss with your client, the buyer, whether or not they expect that item to stay and be included in the sale. I will tell you that most buyer clients, expect these things to stay, particularly the things that I've highlighted here: stove, refrigerator, wine refrigerator, washer, dryer, etc. All the video doorbells and all that, they expected to stay. You have to check the box if you want it to remain at the property. I've had a lot of agents have to pay for a washer or dryer after close because they forgot to check a box. So have a clear conversation with your client if a property has something that could be removed, that it actually stays. Very important. Then there's a section for excluding items. If there was some item that the seller said that one would have the expectation would be passed along with the property. If there's that item that the seller wants to keep, make sure to highlight it, check the box, and write that you agree to explicitly exclude it from the sale. And then the last section on this page, that's the last section of our grid, deals with who's going to pay for what, the other nitty-gritty. So we said the first page deals with what we're offering for the property and how that's going to look. Second page largely deals with the contingencies we're going to include. A lot of this third page deals with a lot of the smaller or nitty-gritty items or closing cost items and who's paying for what. So there are additional costs that come with purchasing a property that are outside of just the purchase price and down payment and all the rest. There are specific reports like the natural hazard disclosure reports that are required with the sale of a property. Well, who's going to be responsible to pay for it? They're usually about $100, buyer or seller. Who's going to pay for certain escrow fees and closing fees and other city and county transfer taxes? Who's going to pay for these closing costs that happen with the transfer of every property? Well, you'll see most of this page asks the question with the line item, is the buyer paying or the seller paying or both? And you get to check the box for what's expected. The boxes that I've checked here are my examples from what's custom in the areas that I've personally sold in. But I would encourage everybody on this call to talk to their mentor if they're working with a mentor, talk to their individual broker if they're, for their brokerage, talk to their escrow officers, find out what's customary in your areas, because what I have checked here is not always going to be the case of what's customary in the market you're working in. So I'm going to go through, and this is kind of per my experience in a market like Oakland. But if you're working in Fremont, if you're working in Berkeley, if you're working in Alameda, Castro Valley, talk to your mentor first before filling out this page. Escrow companies usually have something called a who pays cheat sheet, because the local escrow company will keep track of what the customs are in certain areas. So things like who pays for a natural hazard report. Well, generally I ask the seller to pay for it because they're generally responsible for it. And then I write who I want to pay, what kind of report I want in. Um, who pays for the optional wildfire disclosure report? In most of the areas that I work in, we don't include one of those reports. We're not required to, so I don't check anything here. There's a section for A and B here in Q3 for us to fill in a kind of report. If there's a home inspection or pest inspection that's yet to be paid for, we could fill it in there. I'm not used to really having to allocate cost for these kinds of reports in most of the transactions I've done. So I leave it blank, but you may have the need one day to be specific about who's going to pay for one of these reports. Who pays for the smoke detectors and smoke alarms, CO detectors, water heater bracing? I usually check the seller is going to pay for that, because the seller is largely responsible for making sure these things are in place. So why shouldn't they pay for the cost? Government point of sale ordinances, who's going to pay for inspections, reports, or remedial actions? I usually leave this blank because a lot of the markets that I serve, we have separate forms that deal with point of sale. Point of sale ordinances are things like sewer lateral ordinances or sidewalk ordinances. Generally speaking, in most of the East Bay, if we have a point of sale ordinance, we also have a specific form that tells us whether buyer or seller is going to pay. We usually provide those along with the purchase agreement because they're usually included in our offers. Um, Um, so that's where we are there. I usually leave it blank and just let the form talk for itself. Escrow fees in the markets that I've worked in the East Bay, oftentimes the buyer will be responsible for escrow fees, owner's title insurance fees. So I check that here, but check with your mentors, etc. In the markets that I've worked in, the seller usually pays the county transfer tax fee, and the buyer and seller, if there's a city tax, usually pay together. They usually share the cost because they're usually larger, etc. So go over this who pays section with your mentors if you're new in real estate. If you're not new, you should know these things by the areas you serve. If you don't know the areas you serve, talk to your escrow officers, and you have to map some of this out when you're writing an offer. And lastly, on this page, we have this home warranties. Home warranties will usually cover certain maintenance of certain items and repairs of certain items like appliances around the house. Different policies by these third-party providers will even cover some of the systems, electrical systems, and some will cover things like AC and heating. These are these third-party products that a buyer or seller can buy to cover the property for a year, usually, sometimes 2 years after close of escrow. If something breaks, you can call that and get the policy to take care of these small fixes. They're usually under $1,000 and they come in really handy. And you can ask who's going to pay for that here. So that's the third page of the purchase agreement, just dealing with the nitty gritty. Work if you're new with your mentor on filling this out of the purchase agreement. And that's our grid. That's what we're tailoring to try to put an offer together to lob to the other side. There's some other items on page 4 before we go over to some other things I want to show you for when we're in a specific kind of transaction that's a little bit different from a normal transaction or regular transaction. Like if we have a probate sale, property that's being bought is in probate, or if it's a manufacturer or mobile home, or if we've got some special kind of property that's a tenancy in common property, et cetera. There are a couple of options on this page here for, the idiosyncrasies of sales that aren't our typical sales. And you'll use these boxes when you're in a specific kind of sale, and you'll know that you need to kind of add these extra addenda on because it'll be obvious. You'll be in a house that's not your normal house or a property that's not your normal everyday property, and you'll check the different kinds of addenda or that you may need here. But otherwise, after we move on from the grid in that small section, we're largely dealing with these informational paragraphs that I addressed before that tell us how this contract works and the things that we can expect in this contract. And they give us further details about things that we're agreeing to here and that we've agreed to in the grid. You should become familiar with it, how loan contingencies work, how the actual contingency process works, what to expect when we're removing contingencies, what goes along with a notice to perform if we send one because we want somebody to remove a contingency, what our obligations are, what cancellations look like when cancellations have to happen, et cetera, et cetera. It gives us more details about the specifics, what documents are required in real estate sales. But what we went through today largely were those things that change with every transaction when we have to tailor a purchase agreement and lob it over to the other side for agreement. There are two pieces, though, that are not in the grid. There are at least two pieces that are not in the grid that I have to show you very specifically that we have to consider when we're working with a buyer to decide on what kind of offer they want to write. Those two pieces are two paragraphs later that do require a little action, and they're both in boxes here. You'll see paragraphs 26 and 28 are in boxes. Every other paragraph we just passed by is not in a box. These two are in boxes because you'll see they require initials from all parties or no initials. They're called meeting of the minds paragraphs, and they're in boxes because the thinking here is there are two paragraphs or clauses that we're going to include in this contract if all parties agree to include them. Otherwise, they don't exist. They're in boxes. If they're not agreed to with initials, they just don't exist as part of the agreement. So we have to address these with our client, and we particularly have to address them because they're kind of important. One of them is, do we want to make this liquidated damages portion included in the contract? What's liquidated damages? Liquidated damages is saying if somebody fails to complete what they're supposed to complete, they fail to close escrow, they fail to purchase the property. If the buyer fails and defaults and they cancel and they're in the wrong, what's the seller's option in terms of recovering damages, going after the buyer? If this liquidated damages section is initialed by a buyer, the buyer is saying, okay, we agree if we do something wrong, if we fail, if we breach contract, that you can come after us, but only for up to 3% of the purchase price. We are capping what you can come after us for. So rather than going after actual damages, which could be anything, could be $50,000, $100,000, we're agreeing in advance that you'll only come after us, that we're all agreeing that you can come after us for 3%. So rather than trying to calculate how you've been damaged, seller, if we fail and cancel and we had no right to do so, we didn't have any contingencies, you can basically take our deposit because that we said customarily we leave 3% in as a deposit. So this liquidated damages paragraph, which is a meeting of the minds paragraph, it's one that's got to get initialed if we want to include it. It's a kind of no-brainer that a buyer would want to initial it. So everybody on this call that's representing buyers, generally speaking, most buyers want to cap their damages, want to say, I don't want you to come at me from some unlimited amount later if I screw up. I want to cap damages. But again, we bat this over to the other side as a proposal, and we'd need the seller's initials to make it formal. It's got to be both sides agreeing on it to initial, or both sides agreeing not to initial. But most of the time, most buyers want this in. And I, as a lot of you, I'm the broker for a lot of you, I highly, highly advise that we want our clients to have this in the contract because it limits what the other side could go after. And sellers usually agree. It's usually agreeable to have that number defined. The next paragraph that we have to decide on, or that needs all initials, is this arbitration paragraph. But before that, we have this paragraph that doesn't need to be decided on. It's always part of the agreement. It's a mediation paragraph. Any real estate transaction that goes south, where one party has breached, is in the wrong, has done something to destroy the deal, or maybe the deal closes but has created a problem, that all those disputes will go to mediation first. It's included in the contract. It doesn't take initials. It's just part of what happens. We had CAR, our state association, has a mediation center, and most of the mediations will go right there. So if there's a dispute, it goes to mediation. But after mediation, mediation is, it goes to a third party who listens to all sides and advises on which way something should go. The mediator makes a decision, and both sides have to decide whether they agree with the mediation decision, but it's not binding. They don't have to agree. So what happens if a problem goes to mediation that arises from a purchase agreement, but both sides don't agree with what the mediator says? If they do agree, then nothing, then they just do what the mediator says and we've got our resolution. But if they don't agree, what happens? Well, it either goes to a lawsuit, like people have to bring it to a lawsuit, or we can agree, instead of going to a lawsuit, all parties can initial here and say, if mediation fails, we'll do arbitration. Arbitration, like mediation, is a third party that's not, going to a courtroom. It's a third party that's listening to all of the aspects of the dispute and making a decision. They're hearing all the evidence, et cetera. Arbitrators are usually like experienced professional, who oftentimes are retired judges, retired real estate attorneys. They will listen to all the facts of the case. But the difference between arbitration and mediation is that an arbitrator's decision is going to be final, and it's not going to go to a lawsuit. It may cut some costs. It might be less costly than a lawsuit. And a lot of people decide that they'd like to go to pre-agree to go to arbitration rather than a lawsuit if mediation doesn't work out. So if our clients sign that they're going to mediation, and the seller agrees, everybody is basically saying, instead of going to a lawsuit if there's a problem, we're going to go to arbitration. But they're also agreeing that whatever the arbitrator decides, they're going to go along with. It's going to be a binding decision, whatever that neutral third party decides on. So that's what we're explaining to our client when they're looking at these clauses, that they have to make a decision for themselves whether they want these included as part of the purchase agreement. And that's what they essentially do. One is to liquidated damages. It's capping the amount of damages that the party that feels that there's the wronged party feels like they can go after. And the second is, if there's a dispute and mediation fails, are we going to go to this third party arbitrator that may save us the stress of going to a courtroom, and maybe save us some money? But we're also agreeing that we'll agree with whatever they said. And again, these are meeting the minds. We need either all buyer initials and all seller initials, or no buyer initials and no seller initials. There's no in between. If we send this over and we have buyer initials on it, which a lot of buyers want to have both of these clauses in, and the seller disagrees to one or the other, they have to counter us and tell us that they want to, we'd be countering it out. The counter actually provides for a remedy right away. It says that if there's some confusion and we're using a counter offer and we don't have some meeting of the minds here, that we're not going to include the paragraphs. So just make sure, if you want this paragraph in, that it is clear through all offers and the counters that come back and forth, that we're explicit that we want these paragraphs included. And work with your mentor if you have questions about this, or call me or your broker. So that's the other element that I need to show you that's outside of the grid. Then we have more explanatory paragraphs. And then we have basically like what amounts to a signature page, where this seller, the buyer who's been proposing this and putting this together, is going to sign. If they're an entity like a trust or a company, they're going to check a box and say that they're not buying as an individual, they're buying as a company or an entity or power of attorney or trust. And they're going to check here and they're going to tell us more about that entity. And then the person who's able to sign for that entity is going to sign their name. If they're just an individual, like most of our buyers, they're not going to check this box and they're just going to sign their name. They're just going to say, that's the offer. This offer that we gave you, everything that we've defined and tailored above is how we'd like to move forward. If you decide, with now our signatures are on it as buyers, we really have reviewed this all, we're confident with it. And if you decide to go forward and just put your signature on this page, we're all in an agreement. So a buyer has to be darn sure that they're happy with what you've helped them put down here, that they've instructed you and they're good with it. Because if it gets lobbed over to the other side and the other side simply puts their signature on it and sends it back and tells you, they agree, then you're in a committed situation. So the buyer needs to be confident going forward. The seller, on the other hand, gets this, and they have a decision to make. They can do that thing that I just said. They can just simply sign it, and then we're in a binding agreement. We've already decided. They send it back, and we're done. We're in an agreement. Or they have a couple of choices. They can counter it, meaning I kind of like your offer, but there's some things I want to change about it. They can give you a backup offer, or they can put you in backup position instead, which means that the seller is saying, I've gotten a couple of offers on my property. I like yours, but I don't like it as much as the other one I got here today. I'm going to let them win that other offer, but I'll put you in backup. If they fail for some reason or they back out because of a contingency, you're going to automatically come into place as the next person in line, and you'll be in contract with us. So backup offer is kind of like winning second place. It's and then the buyer has to decide whether or not they want to accept the backup and be put in backup position, or they can just reject it. So they can accept it, they can counter it, or they can just reject it. They go down to the bottom of the page and they just initial that they're not signing this offer, they're going to reject it. And that's basically the options left over to the seller. And that's why I say it's like lobbing it over from a buyer's point of view in a tennis match, because it's only the first lob over the net with the proposed offer. It can be ratified right away. It can be made a binding offer right away. If the seller receives it on their side of the net and just puts their signatures on it, sends it back over to you. But oftentimes what we get instead is almost like a tennis match. The buyer sends it over and they check the box. It says that there's going to be a seller counteroffer attached. If they sign the offer without saying there's a seller counteroffer attached, everybody is committed. So be really careful if you're representing a seller. If they want to counter it, if they don't like it the way it is, you have to check the box and include a counteroffer before your client's signature goes down. But if they check the box, say there's going to be a counter and sign it, and you receive that back as a buyer's agent, you have to look at that counter. And this is what it looks like. A counter is usually one page. And it usually addresses a couple of the items from that offer that was just sent. And it's from the seller's point of view now. And the seller is saying, I'm countering that offer. And I am going to, and you tell what the date the offer received is, and you say, I like what I see in the offer, except I'm going to change a couple of things. Instead of paragraph 3A, where you say it's $1 million, I want it to be 1.2 million. I'm going to change, and then they can say, we want to change the contingency days. They can change whatever they want. And then they're going to sign their name and send it over to the buyer. And now it's lobbed over to the net to the buyer, and the buyer has a couple of choices. The buyer can just sign it, and if they sign it, it means everything from the original offer plus these changes that you've made, and that's what's going to be put into effect. And the latest document, the latest counter, supersedes everything else. So whatever's in the latest counter is the kind of overlay. So if something's changed in the counter, then it changes that one element of our original offer, and we're agreeing to it. The buyer can just sign and agree to all of that. Or the buyer can say, well, I'm willing to do some of what you proposed here, but not everything. So I'm going to give you another counter. And it keeps getting lobbed back and forth with counteroffer to counteroffer until everybody decides to go forward and stops giving counteroffers. And then we've got our ratified agreement. And that's the basics of the back and forth that happened with the purchase agreement. And I'm pretty much done. I just want to, we're done a little bit earlier than I normally do. I've included other forms in the package, like a buyer representation agreement. If you're newer, you've seen these buyer representation agreement. They lead off with some of those disclosures I told you about. But with every time we write an offer, actually, in fact, anytime we show a property, we have to have some kind of representation agreement in place with a buyer. The buyer representation agreement that you're seeing here that we'd have in place before writing an offer, before showing a property, says, hey, you and I, buyer, have an agreement that we're going to work together through a certain representation agreement. We're going to have an exclusive or non-exclusive agreement. I'm going to show you certain types of properties. And if you buy the property that we've identified that is specific and included in this agreement, you're going to pay me a certain compensation amount. It's not the purchase agreement, so it's not the focus of our purchase agreement class, but I've included it in the link that I gave you because it's something that you need to get figured out with your client, by your client, before you even show them properties. And like I said, with the purchase agreement, there are going to be times where you and your buyer decide, it's really your buyer's decision, that you're going to ask the seller to take over your responsibilities here, that you're going to ask them to pay the commission. So I've included it in your documents to review, but make sure that you have your buyer representation agreement in place. What else did I include? I included that non-contingent offer advisory. If for some reason your client wants to run a non-contingent offer and you're working for a buyer, make sure you have them review this document and know that there are consequences. They could lose their deposit if they decide to cancel and they don't have a contingency in place. I've also included in the package I gave you what a buyer contingency removal looks like. We talked a lot about contingencies when writing the offers, and we've talked about like in 10 days, 17 days, or however many days we've indicated, a buyer needs to remove the contingencies that they're saying that they're going to remove once they're satisfied and ready to do so. Well, this is what the contingency removal looks like. It references the purchase agreement, it talks about who the buyer and seller is, and it tells the seller which contingencies we're ready to remove, what like safety net we're ready to remove. Telling the seller, we're ready to remove our loan or our inspection or our appraisal. Those things that, on day 10 or day 17, we've indicated we'll be ready to remove. When the time comes and the client is prepared, the lender has gotten back to you that the loan is satisfied, or the appraiser's gotten back and said that, you met the appraisal amount, or the buyer has satisfied their investigation and feels comfortable moving forward, it's going to be time for this contingency to be removed. And this is the form we use. So this is some of the kind of auxiliary forms that go along with the purchase process. But hopefully today's purchase agreement class kind of gave you the overview you need for how we tailor these documents. Do I have any questions? Okay, Sunil asked, if there are multiple offers with the seller, they need to send offer not accepted to all who sent offers. So in a circumstance where a seller receives multiple of these offers, the seller has a couple of choices, right? I said on the last page of the offer, the seller can accept an offer, they can reject an offer, they can put somebody in backup position, etc. So how does it look if there are multiple offers? If there are multiple offers, the seller has an option of how they want to counter too. They can counter one of the multiple offers they've received and just reject the rest, not move anywhere with the rest. They can reject everybody. That's one option the seller has, even if they have multiples. Or they can do something called send a seller multiple counter offer. So in the original scenario I suggested, the seller can look at an offer received and they can counter it with a seller counter offer. But in Sunil's situation, Sunil's question, what if there are multiple offers? The seller can reject multiple offers, or they can give something called a seller multiple counter offer. And that's a different form. It looks like a counteroffer, but it's alerting all parties that there's going to be a multiple counter going in, that the seller received more than one purchase agreement and that they're going to be sending out multiple counters. And when they send out a multiple counter, they can change terms on each of those multiple counteroffers to look the way they want it to look as a seller, change whatever intricacies on any specific offer they want to change. And they're basically saying to everybody they're sending those out to, hey, you review this. If you're willing to move forward, you let me know. But then I'm still going to have final say as to which of you who get me these back I'm going to move forward with. So the seller is kind of leaving open the ability to make a final decision again. Whereas with a regular counteroffer, they're just putting it out there. They're saying, I'm going to put out this to my one offer that I received. I'm going to put out this solution that suits my needs. And if you, seller buyer, send it back to me signed, we're in contract. With a seller counteroffer, it works a little bit differently. You're saying, I'm sending out multiple of these, and actually, you just signing is not going to be enough to have us ratified. I'm going to need you to sign and send it back to me because I'm expecting a few more of these back today, these seller multiple counters. And I, as the seller, still gonna have the ability to look at them against one another and decide which to go with. Does that make sense, Sunil? Got it. Okay, great. Are there any other questions, general questions about the purchase agreement, about any of the elements? It's a lot, and you should look at this video again, look at my other class videos on this, talk to your mentors if you're brand new. Always work with your mentor on your first 3 transactions to help fill these out with your buyers. You make sure that you're having really clear conversations with your buyer client, that you're including their lender in. With their approval, you have to talk to the buyer about bringing the lender into these conversations for the elements that concern the lender. Any questions though? Okay, I think we're good then. I hope this was helpful. Can I get a thumbs up if it felt helpful?
Thank
All
you.
right.
Thank
And
you.
if anybody ever has any questions, reach out to your mentor, but you're also welcome to reach out to your brokers. I'm the broker again for Fremont. I'm the broker for Oakland, Berkeley, Alameda, and Castro Valley. If you're in any of those market centers, you're always welcome to reach out to me as well. Okay.
Thank you very much.
Thank you.
Thanks, everybody.
Thank you.